Fulfer is explaining what I'm about to make, what I'm about to request to make sure that our client agrees with it. Your Honor, given the court's ruling on that, we would ask that second degree and manslaughter not be given.
On what basis?
Your Honor, look at the charging document briefly. As I indicated previously, Your Honor, it's our position that the two sentences at the end of the principal instruction, specifically for second-degree murder, it is not necessary for the state to prove the defendant intended the death of Daniel Markell. For manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markell. As I indicated, it's a question of intent, and the principal instruction, the main portion, defendant intended the crime to occur. I just think it's confusing. I understand the state's position, but under the circumstances, we would request that the court not give those two lessers.
Moment.
As I understand it, they're requesting just for count one simply to be guilty of first-degree murder or not guilty?
No, Mr. Evans, to omit the lines pertaining to second-degree murder and manslaughter and the 3.5 sub-A instruction.
Mr. Evans' understanding of our request is accurate. We're asking that the two lessers for count one not be given, and that would eliminate the necessity for those two sentences in the principal instruction.
What is the state's position?
They're talking at the moment, Judge. We're fine with doing away with the lessers on count one.
On this matter, I will need to take a call clear from the defendant. Ms. Adelson, please rise, raise your right hand this morning. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
You can lower your hand. Ms. Adelson, you understand that lesser included crimes are something that is available depending on what is charged as a crime.
I understand that.
Do you also understand as well, if you waive your ability for the jury to make this finding, they can only make a finding as to what is charged first-degree murder?
Yes, that's correct, Your Honor.
In consulting with your attorneys, do you understand the strategy of waiving all lesser included crimes?
I do, Your Honor.
Is there anything that you need to consult with them further about concerning this matter?
No, there is.
Then you may be seated. As to the jury instructions, I will remove second-degree murder and manslaughter as options.
Given that, Your Honor, I believe moving the two principal instructions directly after count one would also be appropriate.
We're removing any reference to second-degree murder and manslaughter in the principal instruction as well.
I did have one style to change that thing that I'd like to consider on principal instructions, the last line.
Give me one moment.
Before moving the two principal instructions after count one, Mr. Evans raised a good point.
Give me one moment. Concerning the principal instructions, Mr. Evans.
Your Honor, the last line in both principal instructions where it says this instruction, currently says this instruction does not apply to count 2. We would suggest that it be changed to this instruction applies only to count 1 and 3. It does not apply to count 2 in both areas.
Defense would concur.
Make the request to change. Let me repeat it once again, so this reflects what is requested. This instruction only applies to counts 1 and 3 and does not apply to count 2.
Yes, Your Honor, and given that principle applies to count 3, I'll withdraw the request to move principle after count 1. So it seems more, it would be more consistent with the fact that principle applies to count 3.
The positioning of the instructions will be after, it will be introduction to homicide, count 1, count 2, count 3, principle 3.5 sub A, principles 3.5 sub B, intent, and then moving on to plea of not guilty, reasonable doubt, and burden of proof.
Yes, sir. And I see you have added 10, the language that was agreed to for both sides.
Yes. Right, as to the defense's request to move in certain portions of the 2023 and 2024 calendars under the rule of completeness. After reviewing this matter, the rule and cases associated with it last night, at this time, that is going to be denied, specifically as to the 2014 and 2023 calendars. These are not what the court would deem as a unified recording or writing. The calendars specifically are broken into separate documents by date. The 2014 calendar, any discussion of planning a party in no way connects with the license plate information that has been entered into evidence, which was done by a witness who authenticated that page, the handwriting, and other matters to reach the admissibility threshold. As that would go to hearsay without an exception or a witness testifying on the matter that will not be admitted. As to the 2023 calendar, these are not united by time or would otherwise lend context between the entries themselves. Again, if there is a witness who would testify to these matters, that would change the analysis. However, that has not occurred. As to those 2 items, they will be made court exhibits if necessary for any future review.
May I be heard on the 2014, Your Honor?
Go ahead.
One of the pages that the state included in, I believe it's 59A, the first page actually refers to the party. And in the state's demonstrative that was used through Sergeant Corbett, they actually highlighted that language. If I can approach.
Demonstrative though is not evidence.
No, in the presentation that they had with Corbett after the document was admitted into evidence, the document itself was admitted. During his presentation, they highlighted language about the party. So I think that changed the analysis. If I can approach and grab the exhibit, Your Honor.
Please do.
calendar. One was the one with the, tag number. I don't see that here, Your Honor.
May I show?
Exhibit 142, Your Honor. And the reference is on Friday, June 13th. It's pretty much in the middle of the page.
As to this particular page, making any arguments as to what's been admitted is certainly permitted. How are the other separate pages, which are separate writings, in any way connected to this as completeness?
And it's all about the birthday party. That using admission of that page alone creates misleading impression.
Again, the court's ruling remains the same. For the item that has been admitted, you can make all arguments that can be reasonably inferred from this admitted item concerning the birthday party. Beyond that, the writings are not connected. This is not an issue of completeness as the court finds.
May we use the calendars as demonstratives during our closing?
You certainly may.
Thank you, Your Honor.
Are there any other issues that we need to raise at this time by either party?
Oh, yes. The verdict form, Your Honor.
Yes.
Mr. Evans and I discussed on count 2 to conform to the indictment. We would ask that the count 2, we the jury find as follows as count 2 of the indictment: conspiracy to commit first-degree murder. And additionally, the conforming word in A.
Let me bring up the indictment. So you wish for it to read conspiracy to commit first-degree murder.
Yes, please.
As to the solicitation, do you wish for that to read the same as well?
Yes, Your Honor.
I believe that stays with the evidence. Any further issues concerning the jury instructions that need to be addressed?
Your Honor, I just want to make sure you under subsection, which says the defendant is guilty of conspiracy to commit, you did add first degree murder there.
The verdicts will read count 1, We, the jury, find as follows as the count one of the indictment. First degree murder, the defendant is guilty of first degree murder. The defendant is not guilty as the count one. Count two, we, the jury, find as follows as the count two of the indictment. Conspiracy to commit first degree murder. The defendant is guilty of conspiracy to commit first degree murder. The defendant is not guilty as the count two. Count three, we, the jury, find as follows as the count three of the, change that to indictment, not information. Count three of the indictment, the defendant is guilty of solicitation to commit first degree murder. The defendant is not guilty as to count three.
Yes, sir.
Any further issues to raise concerning the jury instructions?
No.
None on that, Your Honor.
Any other issues to raise?
I'd like to renew our motion for judgment of acquittal, same arguments, as well as all previous motions and objections.
Very well. As to the renewed motion for judgment of acquittal, the court has the same ruling in taking the evidence introduced throughout the trial in the light most favorable to the state. The state has met its burden to present all three counts to the jury. As to any review on this matter, the issue is preserved.
Thank you. And the last issue, Your Honor, we had discussions yesterday concerning a corrections officer at the Leon County Detention Center. We were able to get her served. Our investigator was able to, an investigator was able to track her down. Ms. Kessler, my paralegal, spoke with her afterwards. The information that she provided is our position that anything Officer Franklin would have to offer is not admissible. And that is why we did not seek to call her prior to arresting.
Well, parties can briefly approach. Before we bring the jurors in, we will have a brief break to allow the parties to get set any demonstratives and presentations that they will need for closing arguments. Please inform the jurors that we will bring them out about 9:25. Until then, the parties may do what they need to do to set up to get ready. I will print the copies of the instructions. If anyone needs to stretch their legs, use the bathroom, please do so. As to all observers for the closing arguments today, and this is very important, once again, you are not to make any gestures. You're not to make any facial movements. You're not to any way indicate to the jurors that you agree or disagree with what is being argued or what is being said. Phones need to be put away and placed on silent or turned off. Does anyone have any questions? Given what was brought up yesterday, that there was either murmuring or some sort of improper influencing or attempt to improperly influence the jury, that is not going to be permitted. You will be removed and also subject to contempt. Please raise your hands now if you have any questions. Otherwise, I expect you to conduct yourselves accordingly. We will resume at 9:25. The parties are to prepare for the closings at this point, or all presentations and demonstrations. very quickly. Yes.
All right, jury entering courtroom.
Everyone can be seated. Good morning, members of the jury. Before we get started with the instructions on the law and the closing arguments by the attorneys, I will have a stipulation to read to you. When the parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact that you must accept as true is that Patricia Byrd was not listed by the current or previous defense counsel as a potential witness in this case. Does each juror have a copy of the jury instructions in their seats? Please raise your hands. For the record, each juror has been provided with a copy of the instructions. I'm going to read these instructions out loud to you. You may follow along by reading as I read them out loud, or you may listen. The important thing is that you pay careful attention to the instruction on the law. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Donna Adelson, the defendant in this case, has been accused of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. Donna Adelson is accused of first-degree murder in count 1 of the indictment. If you find Daniel Markell was killed by Donna Adelson, you must then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder. I now instruct you on the circumstances that must be proved before Donna Adelson may be found guilty of first-degree murder. Count 1. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, Daniel Markell is dead. Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was a premeditated killing of Daniel Markell. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Count 2. To prove the crime of criminal conspiracy, the state must prove the following 2 elements beyond a reasonable doubt. Element 1. The intent of Donna Adelson was that the offense of first-degree murder would be committed. Element 2. In order to carry out the intent, Donna Adelson agreed, conspired, combined, or confederated with Charles Adelson or Catherine McBanawa or other persons to cause first-degree murder to be committed either by them or one of them or by some other person. It is not necessary that the agreement, conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or that words pass between the conspirators. It is not necessary that the defendant do any act in furtherance of the offense conspired. Count 3. To prove the crime of criminal solicitation, the state must prove the following 2 elements beyond a reasonable doubt. Element 1. Donna Adelson solicited Charles Adelson or Catherine McBanawa or other persons to commit first-degree murder. Element 2. During the solicitation, Donna Adelson commanded, encouraged, hired, or requested Charles Adelson or Catherine McBanawa or other persons to engage in specific conduct which would constitute the commission of first-degree murder. It is not necessary that the defendant do any act in furtherance of the offense solicited. The crime of first-degree murder has been previously defined in these instructions. To solicit means to ask earnestly or to try to induce another person to engage in specific conduct. If the defendant helped another person or persons commit a crime, the defendant is a principal and must be treated as if she had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. To be a principal, the defendant does not have to be present when the crime is committed or attempted. For first-degree premeditated murder, the state must prove the defendant intended that the killing of Daniel Markell occur. This instruction only applies to count 1 and 3 and does not apply to count 2. If the defendant paid or promised to pay another person or persons to commit a crime, the defendant is a principal and must be treated as if she had done all of the things the person who was promised or received the money did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, she made or promised the payment in exchange for the commission or promise to commit the crime or to help commit the crime, and 3, the crime was committed by the other person. To be a principal, the defendant does not have to be present when the crime is committed. This instruction only applies to count 1 and 3 and does not apply to count 2. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory?
Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony or a misdemeanor involving dishonesty? Was the witness present in the courtroom during the testimony of another witness or other witnesses? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Check on what's happening in the hallway. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime or hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number 2, This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. Number 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Number 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. There is only one verdict form, which I am in possession of right now, but I will read to you all of the options that are available on the verdict form. State of Florida versus Donna Adelson, defendant, case number 2023 CF 3226. Verdict, count 1. We, the jury, find as follows as to count 1 of the indictment, first-degree murder. Check only one letter choice as to this count. Letter option A. The defendant is guilty of first-degree murder. Letter option B. The defendant is not guilty as to count 1. Count 2. We, the jury, find as follows as to count 2 of the indictment, conspiracy to commit first-degree murder. Check only one letter choice as to this count. Letter option A. The defendant is guilty of conspiracy to commit first-degree murder. Letter option B. The defendant is not guilty as to count 2. Count 3. We, the jury, find as follows as the count 3 of the indictment, solicitation to commit first-degree murder. Check only one letter choice as to this count. Letter option A. The defendant is guilty of solicitation to commit first-degree murder. Letter option B. The defendant is not guilty as to count 3. And then the verdict form is to be signed and dated by the individual who will serve as the foreperson. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Is the state prepared to proceed with its closing argument?
Yes, Your Honor. May I please the court? Counsel. Good morning. Well, this is Dan Markell. He's the victim in this case. A son, a brother, a colleague, a mentor, a professor, a friend, but most of all, a father, an Abba, a dad. A dedicated and loving father whose downfall was brought about by the fact that his number one priority was maximizing his time with those little boys in the wake of a bitter divorce from their mother. Defense called witnesses to come in here and give you an expert opinion that his divorce and the subsequent litigation was not contentious. Not contentious to whom? It was contentious to Dan Markell. It was contentious to Wendy Adelson. And it was contentious to this defendant. And then after telling you what a great guy Dan Markell was in opening statements, they called witnesses to tell you what a pain in the butt he was. And he was a pain in the butt to those people, those awful lawyers that can't even admit that divorces are emotionally charged. He was a pain in their butts. He was a pain in Wendy's butt, and he was a pain in Donna's butt. Why? Because this was his life we were talking about. Dan Markell was not a file on some lawyer's desk. He was a real person who cared passionately about every scrap of paper in that divorce file. He wasn't some bumbling idiot. He was a Harvard-educated law professor. And yeah, he was making it as difficult as possible for this defendant to get her non-negotiable, which just also happened to be Dan Markell's non-negotiable, those two little boys. You have learned about this conspiracy and how it has unraveled over the last 11 years since Dan Markell's death. The defendants in this case have all attempted to point fingers at each other. They have argued that the state's theory is right. It's right. You got it right with everybody except for me. I didn't do it. Garcia's defense was that Charlie went directly to Rivera to arrange the hit on Dan Markell. Catherine Magbanua testified in her trial and said she had no knowledge of this murder. Charlie must have gone around her directly to Garcia. In Charlie's trial, he said Magbanua, Garcia, and Rivera all got together to kill Dan Markell without any direction from any Adelson family member. Each defendant characterized himself or herself as another victim in this case. A victim in this situation, a victim of their co-defendants, setting them up, or the appearance of evidence that seemed to implicate them but wasn't what it appeared to be. But despite their efforts to insulate themselves and to distance themselves from their co-conspirators, they made enough mistakes to get themselves caught and held accountable for their respective roles in this conspiracy. And today is Donna Adelson's turn. Despite their efforts to play victims, Dan Markell is still the only victim in this case. And the only thing he was guilty of was fighting like hell for those little boys. And he lost. He lost everything. This is what he looked like before. This defendant conspired to hire a hitman to have him killed. And this is what he looked like after. Evidence has shown that on July 18th, 2014, this brilliant, accomplished, beloved man was gunned down in cold blood in his own garage. This horrific death ultimately set the police down two separate paths, following the two most promising leads that they had. The first lead was to chase down that Prius that, thank God, Mr. Geiger caught a glimpse of pulling out of the driveway that morning. And the second path was to ask, as we would with any murder investigation, who had a motive to want him dead? And within 1 hour of the shooting, well before Professor Markell had even been pronounced dead, this path was already pointing to the defendant when Wendy Adelson revealed to officers that her parents had more reason to dislike her ex than anyone else. And what offense had Mr. Markell committed against Donna Adelson and her family, refusing to let his children be taken away from him? Objecting to her telling his kids that he's stupid? The evidence has shown that Donna Adelson was all about psychological warfare, and when all else failed, she was willing to do whatever it took to accomplish her non-negotiable, to get a win. In order for you to render a verdict of guilty, the state must prove to you beyond a reasonable doubt that these crimes were committed and that this defendant is the person who committed the crimes, or in this case, one of the persons who committed the crimes. It is undisputed that these crimes were committed. This was a first-degree murder. No doubt about that. But who did it? The only issue left is identification, or what we call ID. The defense told you in openings, motive doesn't really matter. Don't pay attention to all the motive. Don't pay attention to all the emails. But motive can be compelling proof of who done it. Identification. And thus, critical to your determination of the defendant as one of the persons that committed this crime. Despite some of the testimony that you heard, it is clear that the divorce between Wendy and Dan was contentious. Except the person who cared most about Wendy's divorce and relocation specifically wasn't Wendy. It was her mother. Charlie Adelson solicited Catherine McBanoa to kill Dan Markell, but why? Who solicited Charlie? Because Charlie didn't care about the Adelson family getting a win against Dan Markell. He didn't care about relocation. He didn't care about Wendy's divorce. He cared about go-karts and jet skis and pretty girls. But he also cared about getting things done for the number one woman in his life, and that was his mother. She managed Charlie's life for him, and in return, he solved problems for her. That pattern is seen throughout this case. He talks to Wendy on the defendant's behalf to get her to pull the plug on the Tallahassee house, to date Dave and invite him to Mother's Day, to pursue a medical malpractice job, even though that's not even her area of the law, and on and on and on. She micromanaged Wendy's life. Charlie knows how to manage Wendy in a way that Donna can't, or knows how to talk to her in a way that Donna can't. And Wendy needs their help, right? Because according to them, she doesn't even have enough of a brain in her head to run her own life without their help. Donna decides what's best for everyone, and if she runs into any problems making that happen, Charlie is her go-to guy to get it done. He is the problem solver. And what was the biggest problem that Donna Adelson had in 2014? Dan Markell. Wendy filed her petition for divorce on September 10th of 2012, and the defendant was right in the middle of it. In the fall of 2012, the defendant told her son, Rob Adelson, that she had been in Tallahassee for several months, renting a new place for Wendy. She used her own maiden name to do that, to disguise the identity of who was renting it, arranging for movers, moving money around, and getting things set up for Wendy to leave Dan. Then Wendy calls Dan Markell and delivers the news that she's leaving him. How does she do it? She tells him she and the boys are moving out of the marital home, and the defendant gleefully, that was Rob's word, reported to Rob, her son, that she and Wendy strategically planned to deliver that news to Mr. Markell so that he would get this bomb dropped on him right as he's about to take the stage to deliver this lecture. According to Mr. Markell, in one of his filings, quote, while the husband was away on a short business trip, the wife left the husband in the marital home, taking with her the children's furniture, clothing, toys, and whatever assets, both marital and non-marital, she desired. The evidence has shown that from the start, this defendant was very involved in managing Wendy's divorce. In October of 2012, defendant writes an email entitled, "Things to discuss at your mediation to make sure you have in writing for a settlement," in which she refers to Wendy as a hostage and a prisoner in Tallahassee. That's what she believed. The email also includes the suggestion that Wendy pursue a restraining order against Dan Markell, that Wendy should go for 100% full custody of those two kids and relocation, and the threat of this conversion to Christianity. Quote, if he leaves you in Tallahassee, the children will not be attending Hebrew day school. That's not a threat, just a warning. A warning that her friend, Miss Cunningham, on the stand dismissed. Oh, that was just a foolish thing to say, right? But the characterization of these threats as, just something that was a one-off heat of passion thing has been completely destroyed by the evidence in this case, because she repeats it. She plans it with a lot of specificity. Wendy even admitted that her mom was serious about planning a baptism for these kids to change their religion as a ruse to try to strong-arm Dan Markell into giving up those kids. This is an example of the defendant operating with the emotional subterfuge as described by her daughter, Wendy Adelson. Also remember how her son, Rob, described her. She has rigid and fixed ideas of what she wants. And as long as you comply, things are fine. But when you don't comply, things are not fine. Wendy even admitted that if Dan had relented and moved to South Florida, or at least allowed her to move there, they might have co-parented happily ever after. But Dan did not comply, so things were definitely not fine. The defendant ends this email with, quote, we will help you in any way possible for you to come here. In October, this defendant drafted language for Wendy's petition to relocate, including allegations that Wendy had been upset about having to live in Tallahassee since 2005, and a mention of putting the boys in a Christian school and on a non-kosher diet. Again, that's not a threat, just a reality. And the suggestion that the boys live in South Florida with Wendy and Dan just fly back and forth to see his kids. He can just come see them every other weekend by airplane. Doesn't that sound like an amicable, equal time sharing that the lawyers for the defense described was going on here? Wendy's lawyer says she had no knowledge of Wendy's mom being involved in her divorce, but the evidence shows she absolutely was. Wendy sends the proposed petition for relocation from her lawyer to the defendant with a note that says, here it is, let's edit. And the defendant responds the next day with detailed feedback, including an argument that Dan Markell is incapable of taking care of his own children and that Wendy should seek 100% custody. Arguments which Wendy forwarded to her lawyer as her own. And upon receiving the lawyer's answer, she sends the lawyer's answer back to the defendant. That's in evidence. Defendant's thoughts about Wendy's earning potential and her work environment in Tallahassee. Arguments about she'd be better off with this other job that's higher paying in Miami. And defendant says she's been living in Tallahassee, that she, the defendant, has been living in Tallahassee since the petition was filed to help Wendy with the boys. In January of 2013, the defendant advises Wendy on her amended petition to relocate. And this is where the argument is raised about the job as a major bargaining chip in the divorce. The defendant writes here that Dan needs to know that there's no way in hell Wendy is going to stay at FSU. On January 14th, Wendy files an amended petition with request to relocate, which you can read and see. The petition contains many of the defendant's arguments. She couches this relocation in terms of not only important, but like a matter of life and death. Look at these quotes. It will create a major negative change in our lives. It will ruin your entire life. The rest of all our lives, mine, Dad's, and even Charlie's, will be affected by how well she can perform and act before July 31st to try to get this relocation thing turned around. Donna has even started pre-screening men for Wendy to date in the Miami area. In February, Dan files his response to Wendy's motion to relocate, alleging Wendy took his stuff when she left. The sole reason for relocation is to be close to her mother and family in South Florida, and that contrary to what Wendy put in her pleading, he was not seeking to leave FSU. He wasn't trying to move. Wendy failed to comply with their Skype agreement, that Wendy exhibited deceitful behavior, made false statements, showed a lack of integrity, and had unclean hands. Those are some pretty nasty words. Maybe not the worst thing that the defense experts ever seen, but pretty nasty. Dan Markell requests sole decision-making authority for these kids regarding education, medical, and religious matters. The defense lawyer witnesses said, oh, that was never going to work. Maybe that's true. But these were concerns that Dan Markell took seriously. There's tons of discussions in evidence in these binders before you, in the pleadings and in the emails, about Dan Markell's desire to raise these boys in accordance with his faith and his concerns that his wishes were going to go right out the window as soon as the boys went over to be with Wendy or her mother. And defendant took this matter seriously too. She made it crystal clear in these emails that she had no respect for these boys' fathers' wishes for them regarding religious practices. In this email, defendant says she's sitting at Wendy's kitchen table working on Wendy's response to the filing we just talked about that Dan Markell made. So much for her having no involvement in her daughter's divorce. She says in this email to a friend, all Wendy wants out of this is to relocate to South Florida where she has us and Charlie. Danny is making it very difficult. On March 5th, 2013, defendant sends a long email in response to every paragraph of Dan Markell's arguments against relocation, including that Dan's religious practices are fanatical and dangerous to the boys, and that Dan Markell is psychologically unfit to have custody of his children. It's not sounding very amicable, is it? In opening statements, the defendant's attorney acknowledged that Dan Markell was an intelligent, accomplished professor and a dedicated father, and the state could not agree more. But the evidence has shown that her client didn't agree with that. Donna Adelson repeatedly paints Dan Markell as a self-important idiot who's not fit to care for his own children. On March 6, 2013, Dan Markell sends Wendy an email threatening to take her to court over her failure to cooperate with the Skype thing. That comes up repeatedly. Here he says, you've made zero efforts to facilitate that when you or your mother could have easily done so. I don't want conflict or tension. I desperately want peace and joy. Please let that happen, but do not mistake my politeness or desire for cooperation as a lack of firmness. I will not tolerate failures on your part to keep our agreements. They did have a Skype agreement, and she was violating it, and he was furious about it. This email was forwarded by Wendy to this defendant, so she knows about all this stuff. Dan Markell sent Wendy an email in December, which was pretty personal, and in which he is kind of a mea culpa. He apologizes for things that went wrong in the marriage and takes some accountability for what he views as his mistakes in the marriage. And Wendy forwards this email to her mother. Then Donna responds to this personal email and goes through Dan Markel's writings paragraph by paragraph, suggesting how Wendy can manipulate his words against him. Oh, look, he's admitting this here. This will help you in the divorce. And she does it in Wendy's voice. It's weird. Look at it. So although sometimes Wendy seems to be complaining about her mom overstepping, she's trampling my autonomy, it's like she's also inviting her mother into her business and wants her help, but also don't trample my autonomy. In fact, Wendy thanked her mom for the thoughts that she gave on this letter Dan Markel wrote. She also wrote that she never would have left Dan Markel without her mom's support. In May of 2013, the defendant refers to one of Dan Markel's responses as a, quote, 23-page rant. Then she doubles down on relocation as the most important and non-negotiable part of Wendy's divorce. I mean, how many times does she have to tell y'all it's important, but somehow the defense is still, it wasn't important, or it was over. It didn't matter. She notes here that Dan Markel threatened Wendy with federal kidnapping charges. He threatened her daughter with federal kidnapping charges for taking those kids without telling him where she was going when she left. The defendant signs off, "I'm too angry to write anymore." And the evidence has shown that this nice, normal, sweet little grandma certainly was angry. To support the argument that Wendy should be able to relocate because Dan was always traveling on work trips, the defendant sends Wendy this email, and it contains every date, like the date ranges that Dan Markel has been out of town traveling for work since the birth of their first child. That's 4 years. She is able to go back and send to Wendy, he was out of town this date to this date, this date to this date. It's a little shocking that she recorded that information, but we know she is a very detailed person. She keeps these extremely detailed day planners. But Dan Markel's travel schedule is of particular interest. In fact, in light of the fact that the hitman knew that Dan Markel had to be killed on July 18th because he was going out of town the next day. The question is how they get that information. Who had that information? Then the next day, Dan Markel files a memo of law asking for the attorney's fees and saying that, quote, if costs are not awarded, then the wife and her affluent parents who are bankrolling the wife's litigation so they can enjoy closer access to the grandchildren will persist in vexatious and groundless litigation. Dan Markel knew that Wendy's parents and their considerable resources were a big part of why this divorce litigation was dragging on. They thought he was filing frivolous stuff to drag out the divorce and the proceedings, and he thought the same thing about them. On June 21st, the court issued the order denying relocation. When Wendy was on the stand, the defense made a big deal out of, oh, you didn't tell mom it was final, did you? You stipulated to it, didn't you? Which we later learned was because the judge had already ruled at sidebar that it wasn't going to happen. But basically, you kept your poor mom in the dark and she thought this was still something that was viable and you didn't tell her it wasn't. But on redirect, it was proven that that was not true. Defendant did know that the order was final, and she expressed this in an email to her friends. Poor mom wasn't kept in the dark on anything in this family. In fact, the defendant recognized perfectly well that this order meant she wasn't going to get relocation through the courts. She wasn't going to get what she wanted through the legal system, but that wasn't the only way to skin a cat, was it? She wasn't deterred by a loss in court. Instead, she started looking into other options to get a win for the Adelson family. There was testimony offered that everyone knew that there was a slim chance of Wendy winning relocation. Maybe everyone knew that on the lawyer's side, but the defendant didn't know that. She was not happy about this loss in court. Here she laments, unfortunately, after paying a lawyer $600 an hour for 10 months case preparation, the judge listened to Wendy for 1 hour and made up her mind. Outrageous. So at the moment, we will not be allowed to relocate. Note the phrase "at the moment." Jibbers had not beaten the Adelson family yet. Defendant concludes this email anyway. If I sound angry, it's because I am. We're all very upset and cannot believe the outcome. She couldn't believe relocation was denied. When Wendy expresses defeat over the court's order, the defendant isn't having it. She encourages Wendy to never, never, never give up, to take control, to not let Jibbers think he's won anything by having you remain in Tallahassee, and to show this fucker what will make him absolutely miserable. How amicable. Then defendant solicits Wendy to put on the performance of her life because Jibbers hadn't beaten the Adelson family yet. And this is where defendant reveals her plan of action, including having her Jewish grandsons baptized and offering $1 million to Dan Markel to facilitate this relocation. Control is a theme that's featured prominently throughout this email and throughout this case. There is evidence that the defendant controlled Wendy, she controlled Harvey, and she controlled Charlie, but she could not control Dan Markel. He wasn't going to give her a win. As long as you went along with her rigid, fixed ideas, things were fine. But if you didn't, things were not fine. Defendant continues to react to relocation being denied and Wendy's inclination to give up on the matter, including, everyone has a price. Now is the time to start. You said this divorce is not about winning and losing, and it's not a competition. You've already lost relocation according to the legal system. Well, it is about winning and losing. We're trying to get a win. You deserve it. You deserve so much more than a life without family, teaching in Tallahassee. Life is tough. If you don't stand up and take a chance, you don't stand a chance. Please, Wendy, do your part and stand up to him. Make an effort to do this so that our group offer will stand a better chance of being accepted. Don't let this temporary move to Tallahassee ruin your entire life. Fight for yourself, Wendy. We'll be there to help you. Just don't tell us that what you need to do is move forward with a sense of peace. Can't have that, can we? That's giving up. Giving up on relocation was not an option for Donna Adelson. Neither was losing. Throughout the trial, the defense tried to distance themselves from these emails. One of the ways they did that was by trying to put them off on Harvey. They pointed out, hey, this is a joint email account. One of these is signed mom and dad. And there's a few that are signed mom and dad, but it's clear that the defendant is the author of these emails and that she's the one driving the bus on this relocation effort. And during the presentation, we highlight all the dad and I language, all the indications in there that Donna is the author as opposed to Harvey being the author. According to her own daughter, Wendy, she's the dominant force in that household. And according to her son, Rob, she is a controlling person as opposed to the more passive, go with the flow type of personality that the dad, Harvey, has. In opening, the defense attorney told you that this defendant was a normal person, and you don't have to decide she's not a normal person. You're the judge of the facts, right? Was a crime committed? Is this the person that committed the crime? But in this email, she suggests that dressing her Jewish grandchildren up in Hitler youth uniforms would be acceptable. That would accomplish her goals. The ends justify the means for her, people. That is illustrated here, and it sums up this entire case. The defendant wanted this done because that was the only way left to get a win. If he had submitted, if he'd let her take those kids, he'd be alive. If he'd moved to South Florida himself, he'd be alive. But he would not submit. She could not get that win. He was a huge problem, and she made it Charlie's problem. To Charlie, who liked the idea of being a tough guy, who had connections to people on the wrong side of the tracks, The price of Dan Markel's life was worth the reward of pleasing his mother and easing her diarrhea and getting her to finally shut up about Wendy's divorce. In the mind of this defendant, all their lives depended on the success of this relocation effort. She tells you as much herself in these emails. Listen to her. And as such, any and all means were justified. Because not everything one has to do in life is comfortable or easy. Sometimes it's ridiculously hard. This is what passes for normal in this family. I said the defendant made Wendy's divorce Charlie's problem, and the evidence shows that the defendant did keep Charlie in the loop every step of the way. Here's a July 10th email that states, just to catch you up on what's happening with Wendy, and discusses who should be involved in the bribe that the family wants to offer to Dan Markel. On July 19th, the defendant requests and Wendy sends her copies of the motions, responses, orders, and transcripts from her divorce so far. That same day, Dan Markel makes a settlement offer that this defendant encourages Wendy to reject, saying the answer is no to all of this. Please, Wendy, we've been with you from day one. Do not accept or sign anything without the two of us reviewing and discussing all of this with you. Screwing him financially is what will aggravate him. But ultimately, a settlement is reached. You all have heard about this date, July 31st, 2013. But contrary to what the defense has told you, the fighting did continue. On October 12th of 2013, 3 months after the divorce was final, the defendant forwards an email to Charlie Adelson, which Dan Markel had sent Wendy. And the defendant adds the note, "This is what this fucker is sending your sister on a regular basis. He is absolutely crazy. Impossible." Does it sound like everything was over? This was the amicable divorce over? Not contentious at all, right? This is fall of 2013, the same time frame in which Wendy starts dating Jeff Lacoste and Charlie starts dating Catherine Magbanua. On October 13th, 2013, the defendant texts Charlie Adelson, quote, "Horrible evening for your sister." The pattern of this defendant getting worked up about Wendy's divorce and then forwarding it on to Charlie is seen over and over again. Which brings us to Halloween 2013. Several important events in the case occur on Halloween 2013. One, Wendy officially takes Dan Markel back to court, filing her motion to enforce the marital settlement agreement. So she's alleging he violated it, and she's asking to hold him in contempt of court, alleging that he's not paid the agreed upon fees that he was supposed to pay by a certain deadline. Wendy backs out of the contract that she had signed to buy a house in Tallahassee on Halloween 2013. Charlie later brags to the defendant that he talked Wendy out of buying the house, and the defendant calls him a miracle worker for having convinced Wendy not to buy the house in Tallahassee. Also, Charlie meets up with Catherine Magbanua on Lincoln Road on Halloween 2013, the same day Wendy pulled the plug on the house, and broaches the subject with her for the first time of, "Hey, do you know anybody that I could hire to harm someone?" And she did. Charlie sends this picture of himself and Catherine Magbanua together to Wendy that night, October 31st, 2013. First night, he solicited Catherine Magbanua to be a part of a murder, or a part of what would become a murder. Mid-November, Jeff Lacoste meets the defendant for the first time. Remember Jeff? He was Wendy's boyfriend that testified. He said he would meet her 6 to 7 other times in addition to that first time during the course of his relationship with Wendy. Sometimes just in passing, picking Wendy up for a date. Other times more substantially, including taking the boys to the circus. And that becomes maybe important later. Meanwhile, the fighting continues into December. We're in December of 2013 by now. On December 16th, Dan Markel emails Wendy and the parenting coordinator that was assigned to help them try to navigate these issues about the defendant, Donna Adelson, disparaging him to his kids In this email, he introduces what he calls a major issue. The headline on this concern is not buried, guys. Like he says, I'm introducing a major issue. He very plainly gives a preview of the grandma motion, which will ultimately be filed in March of the next year. And here he says that on November 8th, one of the boys announced at a Markel family dinner that grandma, referring to this defendant, says you're stupid. Grandma says you're stupid. Then the following Monday, on November 11th, when Dan Markel was buckling the boys in at the park, they both tell him that grandma says you're stupid. When asked why, they say because you're trying to take her sunshines away from her. When asked who are her sunshines, the boys answer they are her sunshines. Then again on November 30th, while playing with the older child, that child repeated the statements to Dan Markel, grandma says you're stupid. And again, when asked why, the child repeated that the defendant said that Dan Markel was stupid because he was trying to take grandma's sunshines away from her. Markel implores Wendy to address the situation as he would like to avoid a hearing in which his kids are going to be primary witnesses against their grandmother. He assures her that he will, though, if necessary, seek judicial relief that prevents contact between the children and their grandmother. This lawyer that testified said, oh, that wasn't going to work. Well, he didn't think so. Oh, well, that's no big deal. I've seen much worse than that in my career. Well, yeah, Dan Markel hadn't seen much worse than that. Dan Markel had a big problem with grandma saying he was stupid, and he wanted to take it up and address it with the judge if necessary. Dan Markel emphasizes that this is a matter he takes very seriously and says that the defendant's actions could lead to the termination of Wendy's parental rights. Is that true or not? Doesn't matter. He thought it was true. He threatened it. And those are fighting words. Going to terminate your parental rights. Wendy forwards the email to the defendant the next day, December 17th. And what's the response? Wow. That's a response we see from the defendant quite a bit. She's usually more verbose. That's true. But why is the defense working so hard to say that their client didn't see this email and didn't know about these allegations? I mean, isn't it clear that Wendy is sharing all the issues relating to her divorce with her mother? Wendy communicated with her mother on all these filings, and this one pertained directly to her mother. Of course they discussed it. Are you really to conclude that nobody was fighting anymore prior to Dan Markel's murder when the evidence leads you to conclude the exact opposite? This was a pressure cooker, and it was being turned up hotter and hotter with each passing day. Not only is this a situation that's escalating between the actual parties to the litigation, but now the defendant has moved from working behind the scenes, helping Wendy with the divorce, to actually being the subject of the pleadings that are before the court. There was supposed to be a hearing on that issue. One thing Dan Markel wrote in this email is, quote, I fear that the children's best interests are not being pursued so much as what grandma wants. If he only knew how legitimate that fear really was. Those weren't just some ugly, foul words thrown around in the heat of the moment, folks. They continued well past the finalization of the divorce. Here on January 10th, 2014, so now we're into the year where Dan Markel is killed. 6 months after the divorce is final, defendant says of Dan Markel, wow, is he on drugs? Is he also going to pay $70K plus the legal fees and interest that bastard owes you? So the bad blood is going strong here 6 months before the murder. And the divorce wasn't really final anyway, in the sense that we're continuing to have pleadings get filed back and forth. In February of 2014, Dan Markel emails Wendy threatening to file motions, exposing her for what he said was hiding assets, $200,000 worth of assets from the court, and giving false testimony under oath. And also to accuse her attorney of misconduct. Her lawyer witnesses say none of that's a big deal, none of that was going to be successful, but he thought it was going to be successful. To him, it's a lot of money. To him, it's a big deal. The next day, on February 15th, 2014, we see a text from the defendant to Charlie. Wendy's totally stressed out. Yesterday was a rough one. She will probably have to go through another depot. Outrageous. Rob Adelson testified that his mother told him they were, quote, depoting Wendy to death. But then their expert witness got up there and said Wendy was never deposed. I guess they didn't provide her with that information or any of these emails or text messages post July 31st, because this thing was not over on July 31st. In this text, defendant accuses Dan Markel of stalking Wendy, and Charlie agrees. The defendant tells Charlie to keep the conversation with Wendy light and don't bring up the divorce drama, which kind of implies there was divorce drama going on. There's a sense in this email and elsewhere in the evidence that defendant and Charlie have to tiptoe around Wendy, like she's this damsel in distress that needs the two of them to step in and help her handle her business. On February 17th, 2024, defendant again reports to Charlie how Wendy's hearing went and talks about how there are plans to seek to have Dan Markel forced to submit to psychological testing. Here, defendant is 7 months after the divorce and just 5 months before the murder, responding to Dan Markel's filing a request to produce. And she says, it's time to give it to him. Let's aggravate him the way he's trying to aggravate you. And what can your attorney do to be proactive to give him some grief? Can't you meet with her and work out a plan of attack? Something has to be done with this asshole. This is 5 months before the murder. Here, defendant texts Charlie about Wendy yet again. If you speak to Wendy today, tread lightly. Don't ask questions about the depot, her lawyer, etc. Tough time, and she's really stressed out. The asshole showed up at soccer yesterday, and she goes into a story about, he showed up at soccer and they got into it. And then she ends with such a fucker. Super amicable. Then we have this text on March 4th, switching gears. This is about the birthday gift. Defendant texts Charlie that she's going to call him from the bathroom in Gainesville where she can have some privacy. Please pick up because I will have very limited alone time today. Erase this text after you read it. Then the defendant says, we'll speak privately about Dad's birthday gift. So erase after reading. You might think, well, maybe she was just trying to keep the birthday gift a surprise, but why does Charlie need to erase it? Harvey's not with Charlie, Harvey's with Donna. And according to Rob, there were no birthday gifts for Harvey unless the murder was supposed to be the birthday gift. Plus, in the text, Donna wants Charlie to delete after reading the text that doesn't mention the birthday. She doesn't say anything about deleting the one that does mention the birthday. Rob Adelson was present at the birthday party, which did take place between the two trips that the hitmen took to Tallahassee. And there were no birthday gifts, according to him. The defense suggests that the friends coming to the party was part of the surprise, but then they also suggest that Harvey sent the Evite, so I don't think they can have it both ways. You can't send the invitations and be surprised by the friends. The next week, Jeff Lacoste, Wendy Adelson, Catherine Magbano, and Charlie Adelson all go out to dinner. That's the first meeting between Wendy and Jeff and Catherine Magbano. At dinner, Magbano mentions her ex having several run-ins with law enforcement. That stuck out to Mr. Lacoste. After dinner in the hot tub, Charlie bragged about having connections to people on the wrong side of the tracks. Notable in the same time frame, March 21st, 2014, the defendant signs a lease on a condo in South Beach, a condo where Wendy, after Dan's killed, would move in with her kids. They say, oh, that was a weekend place, so it's pretty convenient timing. You just happen to get this other house and have it set up for Wendy to move into after her ex-husband's murdered, and she's able to relocate. 3/26/14, this is when Dan Markel officially files the grandma motion, which takes aim at the defendant raising more allegations about failure to comply with the Skype thing, Wendy leaving the boys with her parents rather than giving him the right of first refusal. And he says, by flouting the right of first refusal, the former wife creates conditions for Mr. Markel to be disparaged in the presence of the children by their maternal grandmother. Dan Markel then alleges all the same allegations about the defendant disparaging him to the kids that he outlined in that previous email in December. Contrary to what the defense said in court, in his prayer for relief, the remedy Markel was seeking was to have the court order this defendant to have no contact with those boys unless she was supervised, because he didn't want her disparaging him to the boys, and because it was a violation of the right of first refusal, in his opinion, for Wendy to leave the boys all the time with her mom and not give him a chance to have them if Wendy wasn't going to keep them. How do you think Donna took this information? She refers to those kids as hers. She was the one sacrificing her time at the office to be up here in Tallahassee doing for those boys. She had invested so much of her own time in this fight against Dan Markel to try to get a win for the family. After all that investment in those kids and all the money spent on the attorneys and all that time spent at the kitchen table working on those divorce filings, Donna Adelson was losing. The boys and Wendy were stuck in Tallahassee. Wendy wasn't working at the law firm in South Florida, raking in a bunch of money and dating some new guy that she pre-screened for her. And Grandma's sunshines weren't in South Florida. That's where they belonged. That's what was best for them. They had lost in court. Wendy wouldn't comply with Donna's plan of action, and Dan Markel apparently wouldn't take a bribe or be strong-armed to allow his kids to come to South Florida. But as it turns out, Jibbers still had not beaten the Adelson family, because there was still another option, the option of hiring the hitman. Charlie joked about hiring a hitman, but he had also been actively pursuing that option at least since Halloween of 2013. Over the last several months, Charlie had several conversations with Catherine McBanoa about this job, which started as a request to harm and then eventually revealed itself as a murder for hire. Recall that McBanoa said that often when she and Charlie would discuss the murder and the pressing need to get it done, he would emphasize to her that the toll that Wendy's situation was taking on his parents emotionally and physically, as they were stressed to the point of being physically ill. So he would often tell her that's the motive. That's why we need to get this done. It's stressing out my mom. On May 16th, 2014, 2 months before the murder, Wendy was added as a resident to that condo in South Florida. On May 30th, 2014, Donna sends Charlie the text, quote, "Horrible morning with Danny. Tough conversation with her." This text was sent less than 2 months before the murder. The drama is continuing. Everyone's still fighting. It's contentious. Prior to the June trip, Charlie had prepared an envelope containing the murder instructions. He told Catherine McBanoa that he used gloves when handling the paperwork inside, that he printed it not on any printer that can be connected to him, and that she was not to touch the contents of what was inside. She was to deliver the envelope to Sigfredo Garcia. She followed these instructions. In early June, she came back to Charlie asking for travel expenses for the hitman. She got a couple $100 to give them to rent a car to come up here. They came, well, let's back up just a little bit. They rented the car June 2nd, 2014. McBanoa drops Garcia off at the rental car place, and then McBanoa calls Charlie on the way home from the rental car place. And you saw the evidence of this in Sergeant Corbett's presentation. Charlie immediately calls Donna on the landline after hanging up with McBanoa. How do we know that he talked to his mother and not his dad, since it was the landline? Well, because a few minutes after that call, he talks to Dad on his cell. So probably didn't talk to Dad on the landline, and then a few minutes later talked to him on the cell. Garcia and Rivera traveled to Tallahassee. This is June 4th, 2014. Rivera notes that Garcia is in possession of a piece of paper. Paper has a photo on it and some information. This information allowed them to locate and follow Dan Markel's vehicle, a black Honda Accord with the tag number 534YBM. Information that the defendant had written in her 2014 planner. Wendy and Jeff Lacoste have their coffee date, at which she cancels their planned trip to California on July 11th through the 17th. She offers no real explanation for why she's canceling, except to say that she's real worried about being able to pick up the boys on the 18th. The 18th, of course, ends up being the day that Dan Markel is killed. Later that night, Jeff Lacoste goes to Wendy's and she's a nervous wreck. She won't tell him what's wrong, but her stomach's upset, and he goes and gets her Pepto-Bismol. The killers are in town when that happens. The hitmen spend a day and a half following Dan Markel around Tallahassee. Here they are near the park there by his residence. They scope out his residence, and although Rivera had already purchased the murder weapon, a revolver that he got on the streets for the express purpose of killing Dan Markel, they lost him, or he was with the kids, or for whatever reason, they did not get the job completed on the June trip. After the hitmen fail to get the job done, Charlie tells Donna on June 7th of 2014 that he's still working on Dad's birthday present. And she says, "I know you'll come through." Sometime around June 11th, Jeff Lacoste went over to Wendy's residence and observed her living room TV to have some impact damage. This was the same TV that Charlie got Wendy as a divorce present because it was cheaper than hiring a hitman. The location and damage to the set did not appear consistent with something the kids could have caused, at least to Jeff. Note that this is over a month before the murder that Jeff observes this damage, so it was hung out there for a while. June 13th, the defendant has a note in her calendar to consider canceling Harvey's birthday party if that's what he wants to do. Now, this is between the June and July trips, that there's a note to herself to talk to Harvey about whether or not he wants to cancel the party. Rob Adelson testified that there was no illness or anything going on in the family that he knew of that would potentially result in the canceling of Dad's party. This note may be contemplating that if the murder had happened on the June trip, that Harvey might decide it's not appropriate to go through with the party and we need to cancel these invitations. Wendy took a photo with Catherine Magbanoa on the beach 2 days after that note to self in the planner. Here she is in front of the South Beach condo, pictured with Catherine Magbanoa. That photo was taken June 15th of 2014. Wendy sends Rob a text with a picture of her and Jeff Lacoste. This is June 28th of 2014. She includes a request to her brother Rob not to tell her parents about her relationship with Jeff. This suggestion of a secret boyfriend later prompted Rob to suggest Jeff as a potential suspect to the FBI, a secret boyfriend. This was also a little odd that she sent this because Wendy never talked to Rob about her boyfriends, and also because Jeff had already met her parents several times. June 30th of 2014, the defendant comes and gets Wendy and the boys from Tallahassee to take them down to Miami. Remember how she doesn't let Wendy drive with the boys to Miami. She rents a car and comes here and picks them up and drives them to Miami herself. And I think Harvey comes with her. Wendy was to be in South Florida for 2 weeks. In the time between the June and the July trip, Charlie begins to put more pressure on Catherine Magbanoa to get the murder done. On several occasions when he and Magbanoa were discussing the murder, Charlie would step out of the room to call his mother and then return and advise her that the murder needed to get done as soon as possible because his parents were so stressed and worried about Wendy's situation. Charlie painted Dan Markel is an awful person to Catherine Magbanua. He was making Wendy's life hell. He was stressing out her parents. Katie knew somebody who could get this thing done, and he wanted it done. Magbanua understood that the murder was needed urgently to relieve the stress on Charlie's mother. July 1st, 2014, we have a single call from Garcia to Harvey Adelson. This call did not connect, appears like it went to voicemail, and we would later learn from Magbanua that this was after an incident in which her two love interests, Charlie Adelson and Sigfredo Garcia, had a little bit of a run-in. Garcia was angry and jealous about Magbanua dating Charlie and tried to confront Charlie. After this attempted confrontation, it's believed that Garcia was trying to call Charlie, but ended up getting Harvey. And that was that one hang-up call, but it ended up being important because it showed up on the tower dump, Garcia's number, and then when we cross-referenced it with all the Adelson numbers, that was the first match that gave us Sigfredo Garcia's name. We would later learn that the real connection between the Adelsons and the killers was Catherine Magbanua and her relationship with Charlie Adelson. The text messages found in Charlie's iCloud corroborate what Magbanua says about the interactions and the call made the day before. So here she's saying, basically, Garcia's being ridiculous and childish. Harvey's birthday Evite goes out on July 3rd of 2014. The Evite addresses the boys by the last name Adelson. Their name was Markel. This is 2 weeks before the murder of Dan Markel. Even though the Evite says hosted by Donna and the party was for Harvey, the defense has suggested that it was Harvey and not Donna that sent the Evites. The evidence showed otherwise, and Corbett told you there was some follow-up from Donna with the Evite people. She sent that email. A text is sent from Wendy's phone to Dan Markel on July 6th of 2014. At the time this text was sent, this phone was present at the South Beach condo where the defendant lived. Dan Markel confirms, yes, I'm going to be in town to get murdered, not specifically, but he's asked, are you going to be in town July 14th or the 18th? Those are the dates the killers were here. And this, despite the fact that the schedule for that week had already been decided way before this text. And Wendy was already scheduled to have the boys on that Wednesday, which is what she's asking about. She doesn't ask about the whole week that he's got the kids. She only asks about the 14th through the 18th. And I think the killers ended up going to Tallahassee on the 15th through the 18th. Obviously, Dan Markel was killed on the 18th. July 11th, 2014, the defendant comes back to Tallahassee to bring Wendy and the boys home. Okay, so bringing her home from the Harvey birthday party. That same day, both Harvey Adelson and the defendant separately, 8 minutes apart, email Wendy Adelson about her TV repair appointment that's going to happen on the day of the murder. July 13th, Wendy and Lacasse meet at Wendy's house, and she's an emotional wreck again for no apparent reason. Lacasse impeached her regarding some statements that she made during a discussion of their relationship that evening in the context of, you know, you got to get past this moving to Miami thing. I mean, you're not going to be able to move to Miami. And she says, you know, yeah, it's not an issue unless something happens to Dan. And she says, can I tell you something in confidence? And she makes the chilling statement at that time that her brother, besides joking about hiring a hitman because it was buying a TV because it was cheaper than hiring a hitman, he also, in fact, had looked into hiring a hitman to kill Dan Markel. This conversation occurred just 5 days before the murder. July 15th, the Prius is rented. July 16th, Rivera and Garcia traveled to Tallahassee. July 17th, Rivera and Garcia followed Dan Markel around Tallahassee. July 18th, murder day. You guys okay? Anybody need a break? Okay. July 18th, 8:11 a.m., the defendant texts Wendy about the TV repair appointment. The TV repair appointment was planned for between 8 a.m. and noon that day. And she says they are on their way over now to help you with the TV sets in your living room. In case she didn't know which TV set it was. This is the TV that Charlie bought as a divorce present because it's cheaper than hiring a hitman. Could it be a coincidence that this TV is also the alibi for Wendy on the day of the murder? While he's being murdered by a hitman? And then, as we know, the defendant later uses TV as code when she's speaking on those wiretap calls. 8:20 a.m., Wendy texts Charlie, "This is so sweet." We don't know what it means, but she's texted him that, and then she deleted it sometime between the time it was sent, 8:20 a.m., and the time that her phone was cell-brighted or downloaded at the police station later that day. 9:04 a.m., Dan Markel leaves a voicemail for Wendy telling her he's headed to the gym and wants to know if it's okay for him to pick up the boys early and take them swimming that afternoon. Wendy says no, he cannot take the boys swimming after school that day. Meanwhile, what's going on across town? The Prius is following Dan Markel into the gym parking lot. There it is at 9:16 a.m. 9:19 a.m. to 9:37 a.m., Charlie and Wendy talk for 18 minutes. Wendy and Dan argue back and forth a bit about him wanting to take the boys swimming, but after getting off the phone with Charlie, Wendy concedes the argument with Dan and says, okay, you can pick them up and bring them back to me when you're done swimming. But of course, the swimming plan didn't happen because Dan Markel was killed. 10:38 a.m., the Prius follows Mr. Markel out of the gym parking lot. 10:45 a.m., Mr. Markel is shot twice in the head, in his vehicle, in his garage. 10:51, the Prius is captured, fleeing the scene on a city bus camera. 11:01, Mr. Geiger calls 911. 11:15, law enforcement arrives at the scene and sets up a perimeter. Dan Markel is rushed to the hospital. He's treated, but the damage is catastrophic. It's not survivable. And he passes away about 14 hours later. 12:30, the hitmen, now headed back south, turn their phones on. They had turned them off for the homicide. They turn them back on. The first phone call that either one of them makes is Sigfredo Garcia to Catherine Magbanoa. They want their money. Where is Magbanoa getting the money? From Charlie. 12:45. So while the killers are calling Magbanoa and heading south, Wendy goes out of her way to visit the crime scene, encounters a roadblock and crime scene tape. Per the officer at the roadblock, she would have been able to clearly see the police activity at her former residence. The residence where her children currently lived half the time and where they woke up that morning. Yet she abruptly turns around and leaves. She does not make contact with the officer to ask what's going on. She does not call the police to inquire. She does not call Dan Markel to say, are you okay? There's a bunch of cops at the house. She does not call the daycare to make sure her children arrive that morning and are okay. Instead, she proceeds to the ABC Liquors, purchases her Bullet Bourbon at 12:49. She's later approached by law enforcement at lunch and gives a law enforcement interview in which she says, my parents have more reason to dislike Danny than almost anyone else. This echoes Rob Adelson's testimony that his mother hated Dan Markel at the time of his murder. And even from the periphery, it was known to Ryan Fitzpatrick as Charlie's friend that his mother did not like Dan Markel. In her law enforcement interview, Wendy suggests her mother is someone who is very angry at Dan Markel. She suggests Charlie when asked if someone might do this on her behalf. She calls her mom, and the defense has put that call into evidence. 7:04 p.m., she tells her mom that there's been a shooting, and afterwards, Wendy expresses relief that they sounded surprised. 8:59, defendant arrives at Charlie's with the murder money. How do we know she went there and that they aren't just old people that drive really slow? Well, there's this message outside your house. I guess we're going to find out what that means, but I guess it's not going to be outside your house. And he says 10 men. Guess we're going to find out what that means, but apparently it doesn't mean I'll be there in 10 minutes and meet you there and get the money. About 10 o'clock, Catherine Magbanowa joins Charlie at the house. Here they are making plans for that meeting. Next slide, please. Charlie answers the door with a gun in his hand. He's extremely amped up. He tells Magbanowa, my parents just left. They both end up taking Xanax and sleeping over there for the night. The next morning, July 19th, 2014. So this is early morning hours, 1:25 a.m. I think we need the next slide. Yeah, 1:25 a.m. Donna and Harvey arrive at their Orlando hotel. In the morning, Charlie puts the money in Catherine Magbanowa's trunk. She's seen at 9:33 a.m. approximately, heading south toward Rivera's house, where she's going to meet up ultimately with Rivera and Garcia and give them the money. Garcia takes the money out of the trunk where Charlie Adelson put it and divides it up between the three of them. Magbanowa says she did not count her cut, but we know she put some of it in the bank, creating the largest monthly cash spike of any of the records we examined for her bank. This cash spike also occurs at a time when Magbanowa was not employed. Rivera says his understanding was the job paid $100,000 total to be split between the three, and that the cut that he received was roughly a third of that at $35,000. We don't know the amount of Garcia's cut, but we know he got at least enough to buy a car and a motorcycle. All right, so July 20th, the defendant and Harvey Adelson take Wendy and the boys back to South Florida. 2 days after, not even 48 hours after Dan Markell is shot. They're gone. Relocation granted. On the way, Wendy receives a call from Detective Isom. She tells him that the call's breaking up, and she hangs up, afterwards referring him to her lawyer. Catherine Magbanowa that day, or thereabouts, opens her Ziploc bag of money and finds her cut to be $100 bills stapled together in $1,000 stacks. How we know Charlie keeps his money. She also notes that her cut is damp and moldy. She mentions this to Charlie, and he tells her that his mother washed the money. Not like laundered, like washed. Rob Adelson gets a call from Donna Adelson advising him not to talk to the FBI. What? Rob Adelson gets a call from this defendant advising him not to talk to the FBI, just in case they call. He says, well, I already did. She says, well, you don't know anything anyway, and hangs up. July 24th, 2014, Dan Markell was laid to rest in Canada. His children were not in attendance. August of 2014, the defendant registers the older child for flag football under the last name Adelson. His name is Markell. This is 1 month after their father was killed, and already he's being erased from their lives. Within 1 year, their names would be legally changed to Adelson. (9/12/14). The defendant refers to the younger child by the last name Adelson. 9/17 of 14. The first check is written to Catherine Magbanua, signed by this defendant. This is the murder money. Even though Charlie has signing authority on this account, he could write these checks. He chooses to connect his elderly mother to a murder payment. If she wasn't involved, there is no reason in the world why she would write these checks. The defense said in opening that Charlie told Donna to write the checks because it was his business. But half of these checks were written after the business was sold back to Harvey on October 2nd, 2015. Regardless of who owned the business.
Rule, members of the jury, you are to rely on your memory of the evidence in this case. You may proceed.
Thank you, Judge. And regardless of who owned the business at the time, all the Adelsons had an interest in the Adelson Institute. All three of them had signing authority on that checkbook. But the defendant is the one that wrote that check. September 17, 2014, and the 43 checks that followed. Is that consistent with what we've heard? That she would just write the checks and not ask any questions? We've heard that she is assertive, she's controlling, she's a details person. She ran that business and those people's lives. She ran a tight ship. We've seen her weekly planners where she plans out every detail of her own life, making meticulous notes. She kept detailed information about Dan Markel and lots of other things. Rob Adelson testified that she's not the type of person who's just going to do something someone tells her to do. She's going to be asking questions. And we heard that Charlie testified that he told his mother about extortion. He says he was being extorted, right? All right, let's fast forward to October of 2015. Charlie's had a couple girlfriends since the murder and is now dating June Mchinda. Remember her? June, one of Charlie's girlfriends that testified, she said they were enjoying a fairy tale relationship in October of 15. During her relationship with Charlie, June observes that Charlie packages his money in an unusual way. $100 bills stapled into $1,000 stacks. June also observes the defendant to be in control of the family and super involved with the grandchildren. However, she found it odd that nobody in the family seemed curious about who killed Dan Markel, nor did they seem upset about the murder. Rob Adelson also noted a complete lack of curiosity on the part of his mother about this murder in the family. When he asked what the defendant thought happened to Danny, she said, quote, "I don't know and I don't care. It doesn't concern me." As someone who liked details and who always stayed on top of everything, her total lack of interest in who killed her former son-in-law, her grandchildren's father, is totally out of character. From July of 14 to April of 16, Donna Adelson got everything she wanted. Wendy and the kids were in South Florida where she could drop them off and pick them up, manage their schoolwork, their tennis, their piano lessons, and have her sunshines with her every day. All the while, she's steady paying for the murder of their father. Everyone is living their best life, thinking they've gotten away with murder until the bump. Everything changed on April 19th, 2016, when the bump occurred. The undercover approaches Donna and hands her a piece of paper. The most human reaction in the world is to look at the paper. Uh-oh. I think we got one more. There we go. The defense told you in opening that this defendant is a normal person just like you and me. There is nothing normal about the way she conducts herself in the minutes, hours, and days after the undercover approaches her with that paper. The bump and the wire were designed to expose the co-conspirators and their roles in this conspiracy, and it did. Here, we're just 10 minutes later. There's only one thing a normal person would do if approached on the street by a stranger who appears to be threatening harm to them in some way. A normal, or maybe I should say an innocent person would, 1, look at the paper. She didn't do that. 2, get to safety. Get help, contact law enforcement or your husband or somebody that's going to come help you get somewhere safe. What you would not do is lead the bad guy right to the grandchildren. The last thing a normal, innocent person would do is go get her little grandchildren and walk right back down the same block with them where this stranger just approached her. But that is exactly what she does. Then she gets on the phone with Charlie and says absolutely nothing about Dan Markel. There's pictures on the paper. What she does say on the wire, which by the way is direct evidence. I know y'all like that. Some direct evidence. When Charlie asked Donna on State's 99 call A, does it involve me or other people? Well, probably both of us. That is direct evidence. If anyone in that jury room wants to acquit her, make them tell you how that is not a confession. In call B, Charlie calls back because he can't stand it. And he asks his mother, will you send me a picture of the bump flyer?
Yeah, let me see this. Do you want to take a picture of the letter and send me the salt ticket?
No, I don't want to do that. Well, why not? Why not? Normal, nice little old lady who knows nothing about this murder and has nothing to do with it. If Charlie's the one making you write the checks and Charlie's the one that knows something about it, send him a picture of it. He's asking for it. She doesn't want to do that. Why not? Call C, Charlie calls back to say, don't talk about things in the apartment. Oh, obviously. Obviously, we can't talk about things in the apartment. What's obvious? Is it obvious to you?
What is it? Kind of that's what they asked for.
This TV was probably about 5. She's the original code talker. This TV, and look what he says. Well, they asked you for $5,000. He decodes it. He's not the one talking in code. He's decoding it and saying what he's picking up what she's putting down. There's no TV mentioned by the undercover operative that approached Donna Adelson on the street. A couple big takeaways for you, please. Innocent people do not talk in code. Second big takeaway, TV is code for the murder throughout this case. You got Charlie's joke, Wendy's chilling statement to Jeff Lacasse, the alibi of the TV, and now here we've got this TV again. A TV that's the alibi for Wendy. It sat broken for over a month so that a repairman could come out to be her alibi on the morning of the murder. An appointment that her parents set up for her which was pointless because the TV was smashed and, of course, could not be repaired. Then she claimed she had an 18-minute phone call with Charlie about the fact that a smashed TV can't be fixed before she got in her car and went to the crime scene, where she did not get out of her car or make any phone calls or make any inquiries about what was going on at the house where her kids lived. Then Donna says that the undercover mentioned an ex-girlfriend.
Yeah.
Whereby, without knowing which ex-girlfriend, Charlie calls not his most recent ex-girlfriend, not the one before that. He only calls one, Catherine Magbanua, because that's the only one he did a murder with. Because he probably did have a general idea what his mother was talking about. When Charlie brings up going to the police, his mother says, that's not a good idea. Why not? Then instead of notifying the police, Charlie and the defendant leave the safety of her very secure building and meet at a marina just 300 yards from where she was approached by the undercover. They were observed speaking very intensely to each other in low tones. After that meeting, Charlie goes to Dolce Vita. This is the restaurant where he meets up with Catherine Magbanua, and we are able to capture some of that conversation that was had there. In that recording, we hear Charlie make statements that are not only incriminating, but that also are totally inconsistent with the defense that he would later offer at trial. Pause on the wiretap here for a moment just to go to what his defense was and what we've learned about that defense. I told you earlier that he said that Magbanua, Garcia, and Rivera acted alone. They just came to Tallahassee and killed Dan Markel, kind of in the hopes that they would get paid. There are several pieces of evidence that Charlie had to explain, and he designed a defense that he thought would do that. First, he had to explain that he's got this close connection between his girlfriend and the hitman. So the obvious defense there is, she heard me griping about Markel and she thought she was doing me a favor, so she did it on her own. Well, the problem with that is normally you're not going to have your extortionist spend the night with you. You're not going to have the woman that has murdered your former brother-in-law spend the night with you. You're not going to inquire about her plans to go to the pool the next morning if she's, just murdered your ex-brother-in-law. So to explain these messages, he testified that he did not believe she was a part of it. She wasn't one of the extortionists. I was extorted by the killers. I had nothing to do with it. No one in my family had anything to do with it. But I thought that Magbanua was just a victim of the hitman too. She was a go-between for them. She was protecting him from them. All the money he and his mom were paying her, cash and checks, were going to the hitman, not for the benefit of Catherine Magbanua. Even the checks that were being deposited into her bank account, he said he believed she was taking out and giving the money to the killers. It was just funneling through her account so she could get insurance for her kids. So Charlie testified that he had previously mentioned to Magbanua the $1 million offer that his family was going to give Dan Markel, and from that she deduced, he's got a bunch of money. So she ran her mouth to her associates, and her associates took it upon themselves somehow to figure out who Dan Markel is and where he was and kill him on their own. Per Charlie, it was Katie alone that came to him on the night of the murder and demanded money on behalf of the hitman, with the threat that if he didn't pay, they would kill him or other members of his family. Since he didn't have that much money, Magbanua then negotiated a layaway plan with the hitman for him to pay her monthly to go toward this amount of money that the hitmen were demanding. He agreed. He opened up his safe, not at gunpoint or anything, and gave her all the money that was in there. And because she needed to show proof of employment to get insurance, that's why that money was funneling through her account. It was all for the extortionist. The problem for Charlie with that was that he had already agreed to put Magbanua on the payroll between the two trips. You see here in June, he hadn't done it yet, but he says, no problem. Okay, so he'd already agreed to do it before she allegedly extorted him. Even though he had signing authority, it's this defendant that wrote those 44 checks. So if he's being extorted, why doesn't he write the checks? It's this extortion theory that we're saying that the defendant adopted when she heard Charlie's testimony and texted everyone she knew that what he just said on the witness stand was the truth. There's a concept in the law known as adoptive admissions. That's when one party makes a statement and the statement is adopted as the truth by another person. So when Charlie says in those first couple wire calls, if there's a threat, you go to the police, it's of interest that Donna doesn't say, what do you mean if there's a threat? We've been extorted for 2 years. There's been a threat for 2 years. Charlie did tell his best friend, Ryan Fitzpatrick, about the bump. So what I want to highlight here is the difference between their conduct during this like alleged extortion that was going on for 2 years versus the way they act after the bump, which we know was a ruse, but was supposed to be like a blackmail effort. So Charlie tells Ryan Fitzpatrick about the bump. He also tells him about the confrontation with Garcia in the roadway on July 1st, 2014. But he never previously confided in Ryan Fitzpatrick about, even though it's his best friend, about being extorted for 2 years by this girlfriend of his or her associates. Ryan also noted a major change in Charlie's demeanor around the time of the bump. He was displaying a level of stress and anxiety that was not present before the bump, evidencing that his story about being extorted the whole time is false. June Mchinda noticed these changes in Charlie's behavior as well, but she also noted a major change in this defendant's demeanor after the bump. Although she didn't know about the bump, around this time she observed the defendant to be a mess. She had a swollen face, was crying, and said she was on painkillers for stress. On the balcony of the Icon, which I'm not sure this is the right balcony, but some high rise, the defendant told June Mchinda she felt Danny was haunting her from the grave. Why would she make that statement unless she felt guilty about having wronged Dan Markell? So keeping that all in mind, let's see if the other evidence in the case makes sense with this Charlie version of events that this defendant has adopted. Starting with his statements to Catherine Magbanua at the Dolce Vita restaurant. Charlie says to Catherine Magbanua, if they had evidence, we'd have already gone to the airport. Even if they bug your phone, you're still not talking about any of this. Like his mother, Charlie emphasizes that the co-conspirators should not talk about what they know on the phone. The cops would only bug your phone to get information about the murder, right? I mean, why are we not talking on the phone if we had nothing to do with it? Why are we not talking on the phone if we're being extorted and we're the victims here? Why are we not reporting it to the police if we're being extorted and we're the victims here? If the cops are listening, we're not reporting it to the cops because we're afraid they'll come kill us if we do that. Well, talk about it on the phone. If they're listening, they'll hear and they'll know you're being extorted, but they don't do that because it's bull. Discussion about how he's going to start arming himself. So Charlie says at Dolce Vita, I'm going to start, I don't remember his words exactly, but he's going to start carrying a gun and he's prepared to shoot. And he goes through a scenario where, you know, he might have to kill somebody in his driveway and the cops will not ask any questions because he's a dentist. If he's been an extortion victim for 2 years, why is he just now starting to carry a gun? And then he says, if somebody comes up to me asking for money in my house, he's going to shoot them. This is the same guy that's been like too paralyzed by fear over the last 2 years to report his victimization to the police or to anyone. This is a guy of considerable resources that could, I don't know, get some muscle or some help or some something, not just roll over and open his safe and give all his money to some girl that's not even armed. This is a tough guy that would never tolerate somebody coming up to him at his house and asking for money. But he's talking to the woman who supposedly did that exact thing, came into his house and asked him for money. He doesn't mention, well, I gave you the money, but I'm not giving this guy any money. You know, it's like they don't mention this extortion. So you see the problem. But this defendant doesn't see the problem. She says that that's the truth. The truth is out. Thank goodness. The truth is out after we remained silent for so long. Defense does not have to prove anything, but through cross-examination and the witnesses they called, they chose to kind of suggest, you know, maybe Charlie was involved, maybe Wendy was involved. But there's no connection to our client. But Charlie's story was that he and his mom were involved in the sense that they were extorted by Catherine McVanois, so they knew who did the killing. They just didn't speak up because they were scared, because they were being extorted. Donna Adelson calls Charlie's story the truth when it suits her to support her son and proclaim his innocence during his trial, but now she kind of wants to distance herself from that because it's ridiculous story. It's not the truth. The truth wasn't out. Don't let her distance herself. She adopted that statement as the truth. She's stuck with it.
Please approach. We'll take you to the jury room.
Yeah, leave everything right there on the chairs, please.
Everyone can be seated. Ms. Fulford, you may argue what you're seeking to raise.
Thank you, Judge. The comments being made in the closing argument of the state, and I don't like to interrupt closing, so I apologize for that. But there have been several comments that have been made that are burden shifting and commenting on my client's right to remain silent. She's stood before this jury and said that the defense has some other version. She said this in a text, but now they're saying something different. We don't have an obligation to answer any of this. She's insinuating to the jury that we're going to come up there and provide her version of events. She chose not to testify.
Mr. Campbell, any argument concerning this?
Ms. Adelson has made adoptive admissions and has suggested other alternative theories that have been developed through cross-examination. I'm entitled to comment on those theories.
Concerning this, Ms. Fulford, as I've heard the closing argument and the evidence, my recall of it and my notes as well as to what occurred during the trial, there were adoptive admissions as it relates to statements that occurred during Charlie Adelson's trial. While she has not testified, the prosecutor has not made any direct comment on her not testifying in this trial. Also, as well, it is clear she has no burden to prove anything. The state is entitled to argue reasonable inferences from the evidence in the record. We will take a break at this time. If the defendant needs to use the restroom, bailiffs, please take her. If anyone else needs to, please stretch your legs or use the restroom at this point as well. Ms. Kappelman, on my clock, you have 35 minutes remaining. You can be seated. The objection is overruled. Ms. Kappelman, you may continue with your argument.
When the bump happens, you get to observe this defendant and her son in action working the problem. Neither of them would ever just lay down and let themselves get victimized by anyone. The bump is an actual recorded example of how these two act when they're threatened by an extortionist, in this case, a blackmailer. And it's the complete opposite of how they say they've been acting before in the previous extortion. Several other things to note about this. Let's just compare like the two extortions, the prior one and the one with the bump. So when the bump happens, they resist, right? They don't open their safe up. It's only $5,000 compared to thousands and thousands of dollars they've been paying. $5,000, they don't pay. They resist. They take action. There are in-person meetings between Charlie Adelson and his mother, Charlie Adelson and Catherine Magbanua, and eventually with Dad too, about the bump and what to do about it. The defendant eventually downloads a recording app and records a call to the would-be blackmailer. So she records this call, an action that wasn't taken in the 2 years that they were being extorted previously. Charlie tells Ryan Fitzpatrick about the bump, although he never mentioned being extorted over the previous 2 years to Ryan Fitzpatrick. They investigate the bump. This defendant questions every aspect of the undercover. His look, his words, his behavior. You know, it's done like that, it's not done like that. Charlie enlists Catherine Magbanua to find out who it is and to handle it, right? Charlie says he's not going to take it lying down. He threatens Nazi shit if they mess with his family. Katie, I don't care what I spend. You better kill him because he's going to be a big problem. If he can't do it, I'll have someone else do it. Now these guys want an extra $5,000. You're going to kill him when you've been paying, I don't know how many, 100 and some odd $1,000 over the past 2 years. You weren't killing anybody then. They don't pay the money. If Mrs. Adelson has been blindly writing these checks every 2 weeks for 2 years, and her son has been paying additional monies each month on the layaway plan to the extortionist, and they've done nothing to investigate it, nothing to report it, nothing to stop it, but now they're going to launch a full-scale investigation over $5,000 more dollars? They don't call out Catherine Magbanua. According to Charlie and this defendant, they've been paying Magbanua now for 2 years, or at least funneling money through her. And here Charlie is talking to the person that's been collecting that money over all those months. But at no point does he acknowledge in that Dolce Vita recording or even allude to this long history of payments he's been making to her. This long history of extortion that's been ongoing through her. While they're still in the restaurant, Charlie gives Magbanua instructions. Say my friends have no idea what you're talking about. And frankly, I don't know what you're talking about, but the name sounds familiar of who's incarcerated. So I'm going to give you something as charity to help the less fortunate, but do not contact these people again or they're going to the police. The whole time you're talking, just say, I don't know what's going on, and only use the words help and charity. Charlie proceeds to give Magbanua a whole lecture on blackmail, which is pretty ironic in light of the fact that his defense is she was blackmailing me or extorting him. And these are just a selection of the incriminating quotes from the Dolce Vita recording that you all heard. After the meeting with Magbanua at Dolce Vita, Charlie calls the defendant in call F and tells her he had coffee with a friend and gave her some good relationship advice. Well, at this time, Catherine Magbanua is living with Sigfredo Garcia. Relationship advice. This means he talked to Katie and she's going to talk to Garcia and they're going to handle it and deal with the problem. Donna seems to understand this from the use of the term relationship advice. In call G, she's less sure than Charlie that this is the police. That's his theory. She's worried it might not be accurate. She says she has a different theory. He assures her repeatedly it's being handled. There's nothing to worry about. Don't freak out. Magbanua does not want to make that phone call, though, and neither does Garcia. And you hear him pretty emphatic on that wire that he's not making that phone call. But everybody starts lying to each other about having called it because everybody wants to reassure the co-conspirator up the chain that it's all good, I'm handling it, it's not going to come back on us. Charlie expresses concern that if they pay the money, they'll create a monster that will demand more and more and more money. And the defendant replies to that exactly. So these calls go up and down the train cars, back and forth and back and forth and back and forth. Donna to Charlie to Katie to Garcia and back over and over again. In call R, Charlie is telling Magbanua that he has a very nice gift for Garcia's birthday. So if we think about his defense, the defense that this guy is extorting him after he on his own went and killed the ex-brother-in-law, he's gonna buy a birthday gift for the guy? The man that he knows killed Dan Markel? And Donna says this is the truth. The truth is out. Once Charlie and the defendant finally decide for sure that the bump is an undercover as opposed to a real gang member, bad guy, you have never seen two people so happy to be under investigation for first-degree murder in your whole entire life. They convince themselves that they're untouchable. It's just the FBI fishing. They don't have anything on us. If they had anything on us, we'd already be at the airport. They're thrilled about it. Even on the call that the defendant staged and recorded to the undercover where she's proclaiming her innocence, it's pretty interesting the words that she chooses. For example, she says, "I'm out of the loop." How odd is that statement? It implies she knows there's a loop and she's not in it. The evidence has shown that the co-conspirators in this case were all on a need-to-know basis for their own protection. That's why Catherine Magbanua wasn't shown the murder instructions. That's why no Adelson had any contact with the hitmen. And that's why the defendant didn't attend the murder meetings with Charlie Adelson and his mother. They were insulating each other. She was out of the loop on the stuff that the undercover was talking about. You know, my brother in Broward, Luis Rivera, she didn't know anything about Luis Rivera. She was out of the loop on that. But she was in the loop on Catherine Magbanua. She knew an ex-girlfriend met Catherine Magbanua. She knew that Catherine Magbanua needed to give relationship advice to deal with the problem with her baby daddy. She was in the loop on paying for this murder, and she was in the loop with Charlie to get a win for the Adelson family. In May of 2016, after the bump, the defendant stops writing checks. The bad guy comes up to you and wants more money. So what do? You stop writing the checks you've been writing for 2 years under some threat? She's still not going to the police, but apparently she's not scared anymore. She's going to stand up to him and stop writing the checks. Okay. Why? Isn't it because she's gotten spooked, because she's figured out this is law enforcement and they're getting close? In May and June of 2016, Garcia and Rivera are arrested. The news of this makes it all the way to Rob Adelson's operating room. When Rob next speaks to his mother, he says, "Hey, they got the guys. They arrested the guy that shot Danny." Getting no response, he brings up the matter again, like, "Did you hear they got the guys that killed Danny?" And she responds, "I've got to go," and she hangs up. That is the last time that Rob Adelson has talked to his mother. because he knew, and she knew he knew. A couple other problems for the defense that I want to point out as far as this whole Charlie story goes. These are kind of mind benders, so bear with me. In 2016, after the arrest of Garcia and Rivera, but before the arrest of Magbanua, there's a text indicating, this is Charlie to Donna. Charlie says, basically that his lawyer was meeting with Garcia's lawyer. If Garcia acted alone and then extorted Charlie, why is Charlie's lawyer meeting with Garcia's lawyer? This is your extortionist. In fact, regardless of whatever the defense is, why are the two of them meeting? Unless they have common interests. And while Charlie's lawyer is at this meeting, he runs into Magbanua. Magbanua hasn't been arrested yet. She's up there seeing Garcia's lawyer. Well, why is she doing that? According to Charlie's story that this defendant adopted, Magbanua is not in on it. She's a victim too of Garcia, her baby daddy, who's a bad dude. Why is she up at his lawyer's office? And when they learn that Magbanua was up there, Charlie says, oh, my lawyer ran into Magbanua while he was up there. He said she's nice and pretty, and Donna says, just like all your girlfriends. Well, why isn't she saying, what do you mean? Why is she up there? I thought she was a victim of Garcia, just like us. All right, so here's another text. This one's from August of 16. In this one, Charlie and the defendant are discussing a newspaper article in the Tallahassee Democrat, which talks about a drug dealer that the killers had contact with when they were here in Tallahassee from Miami. And somehow Charlie deduces this drug dealer is going to be the state's star witness. And they're basically spitballing alternative defenses. This is August of 2016. They've known supposedly who the killer was. The truth came out that the killer was Garcia and that they knew about it since the time of the killing. But here they are saying, well, maybe a drug dealer killed Danny and a drug deal gone bad. This is because the extortion thing hadn't been invented yet. The extortion thing didn't get invented until right before Charlie's trial in 2023, when he's trying to think of what he's going to say from that witness stand to explain all the evidence against him. Rivera gives a proffer. That's on September 30th of 2016. Magbanua gets arrested October 1st, 2016. You would think that if Charlie's story was the truth, he would be sleeping well for the first time in a long time, knowing that these folks that were taking his money and taking his mother's checks were off the streets and behind bars. But to the contrary, you've heard evidence that he started freaking out around that time, and so did the defendant, right? His behavior became erratic. He became angry, paranoid, stressed. Per June, he got a second phone. He started sleeping with a bag of clothes by the bed. He started communicating with her via WhatsApp. In April of 2022, Charlie gets arrested. In that Dolce Vita restaurant recording, he repeatedly refers to the bump as a blackmail attempt. He uses the word blackmail on the Dolce Vita recording. But in trial, he switches that up to extortion, claiming that he and his mom have been extorted by the hitman. That was going on since 2014. But interestingly, in October 16th of 2023, so just 7 days before Charlie's trial started, this defendant, Donna Adelson, Googled the difference between blackmail and extortion. And the difference is that blackmail is the threat to expose some dirt on somebody. I know something about you, and if you don't pay up, I'm going to expose the dirt. Whereas extortion is the threat to harm somebody. You don't pay up, I'm going to harm you. Obviously, when they developed this defense in preparation for Charlie's trial, they realized the term blackmail was not a good word for them because it indicates they were somehow involved. You got to have some dirt. Okay, it needs to be extortion, threat of harm. We're totally innocent. They did this on their own. They came to us. They extorted us. the defendant doubles down on this. So yeah, she said the truth is out, the truth is out. What does that really mean? Well, she doubles down on it when she writes that script for the witness, Donna Bernhardt, who she solicited to come in here and perjure herself to you all. What does she write in the script? Extort, underlined. This script is Charlie's story. She's again adopting it by writing it out for her witness that she's trying to recruit to come in and deliver it to y'all, which of course backfires. And according to the defense investigator who interviewed Bird, her first story involved the word extort. It's pretty unusual. Regardless of what you think of Drina and Bird, it's clear what the defendant was trying to do with them. I mean, when Donna Bernhardt had that script, and it read exactly like Charlie's whole story, with the exception of the part where he told his mom, it was in the defendant's handwriting. That was very compelling evidence that this defendant was trying to buy herself some witnesses. I do want to talk about one more piece that has to be dealt with regarding this whole story of the extortion. And that's that Wendy wasn't in on it. Okay, there's a text November 1st of 2023. So this is after the truth comes out. This defendant texts Wendy Adelson, her daughter, and acknowledges that Wendy doesn't know anything about all this extortion stuff. And like, sorry, we had to keep it from you for so long, kind of thing. If Charlie's defense was the truth, and Charlie and this defendant knew there was a threat to Wendy and her kids from the people that killed Dan, it's a little shocking that they failed to mention it to her. Instead, they let her and the boys move to Miami, where the bad guys were, and, you know, walk up and down the street without any extra protection or even knowing that the killers knew who they were and had threatened their lives and lived there in Miami. The defendant also acknowledges in this November 1st text at the bottom there. Next one. Previous one, maybe. Okay, on that text, which is in evidence, it says, get the quote, "You know I'm next." This is the defendant to Wendy Adelson. "You know I'm next, but that won't happen. I'll take care of that." An important insight into her state of mind when you're considering this evidence about her flight to Vietnam. All right, 11/6/23, Charlie's jury is deliberating. The defendant gets angry about Wendy sending prayer hands. I guess, you know, your brother's on trial for his life and you're sending prayer hands, an emoji. She says, protected his sister for years. Protected her from what? Would he need to protect her from the knowledge that they were being extorted? Or does it make more sense that the protection that's referred to is the murder, and the fact that this defendant is a little angry that Wendy doesn't seem to appreciate what she views as a huge sacrifice that her brother has made for her and her benefit? Wendy's not charged. This was all for her. 11/6/2023, Charlie is convicted. Nothing about the extortion defense adds up for Charlie, and it doesn't add up for Donna Adelson either. It's true that she did not pull the trigger. She's guilty of first degree murder as a principle, which we talked about at jury selection, about how a party who assists in the murder can be charged and convicted the same as the person that pulled the trigger, even if they're not physically present when the trigger is pulled, which is not disputed that she was not. And you all agreed to follow that law, even if you ended up not liking it, right? I don't know if anyone admitted to not liking it, but you don't really know if you're going to like it or not until you have to make a decision. If you don't like it, you still must apply it. I know that I can trust you to do that. We talked in jury selection about the difference between direct and circumstantial evidence. And it's true that this is largely a circumstantial case. You might recall my powdered donuts example. Had direct evidence that it was the kid not covered in powdered donuts, but we agreed that being covered in the powdered donuts was pretty good evidence that that's the child that ate the donuts. This case is not entirely circumstantial. I mean, she's covered in powdered donuts. Don't get me wrong. But there is direct evidence as well. And I want to go over those. To Rob, when told that he'd already spoken to the police, she says, "Will, you don't know anything anyway." That's direct evidence. You can consider that as direct evidence. To Charlie, after being handed an article about Dan Markel's murder, it involves both of us. It involves the two of us. Number 3, 44 checks to the killer, signed by Donna Adelson. Catherine McVanoa admits she was in a plot to kill Dan Markel. And she got 44 checks, and they were all signed by this woman. Next, that license plate number. She had the car, make, model, and license plate in her 2014 planner. Her statements to Bird, she admitted she did what she was accused of. The script written by this defendant in this defendant's handwriting for Drina Bernhardt to come in here and deliver to y'all about stuff that wasn't true. She also speaks in code. Innocent people do not speak in code, ladies and gentlemen. And consider the things she didn't do. She didn't want to talk on the phone. She didn't want to talk in the apartment. She did not want to send a picture of the bump flyer to Charlie. She didn't say the name of Dan Markel. Anywhere on that wire, she did not say his name. Dan, Danny, Gibbers, that asshole, nothing. Why not? And she didn't go to the police. Nice, normal Jewish grandmother approached on the street about a murder and an extortion attempt. She didn't go to the police. Why not? After Charlie's found guilty, the defendant sends this text to Wendy Adelson. Your brother protected you for years. Now you are not guilty. Your lawyer took very good care of you. You can bury me in the dress that I bought for Lincoln's bar mitzvah. Does not sound at that moment as if she's totally committed to attending the bar mitzvah. You heard that open line call where she's making plans to either flee or kill herself. She is distraught over the verdict. And she's distraught over the knowledge that she's next. The defense has tried to sell you that her emergency fast track visa and one-way ticket to a non-extradition country was a vacation. On November 7th of 2023, this defendant Googled a list of U.S. extradition treaties. She was looking for a non-extradition country, and she booked a ticket to one with a stop in another non-extradition country. She applies for a fast-track emergency visa for Vietnam. I wanted it the fastest I can get it. She indicates a 30-day visa is not sufficient. She requests for the longest visa, which is 90 days, which is past the bar mitzvah date. She tries to get Wendy to help with business assistance. And when Wendy doesn't respond, she ends up asking her friend, Annie Cunningham, who y'all met in court. She says, I can't say exactly why, but we need you guys to come here, both of you. Wendy's not responding to us, and we have an issue that we cannot discuss over the phone. Why can't you discuss it over the phone? You're just going on vacation. Annie responds, basically, just say the word. When they leave for the airport, Harvey leaves this note dated 11/12/23 for Wendy regarding what is needed to sell some property, a gun. Donna makes notes in her planner to have Wendy have the lawyer tell Charlie where they are on the lawyer's private line. So the call will not be recorded. Why not? Y'all are going on vacation. You're coming back. You're not fleeing. There's also a note in her planner to cancel disability insurance. That doesn't seem like something one does when they're going on vacation. There's a note, tell Wendy due October expenses, child support through mid-November 2025. They're presumably for Charlie's son planning to pay child support 2 years in advance. So this is made in 23. All right, November 13th, 2023, the defendant is arrested trying to board a one-way flight to a non-extradition country. I mean, y'all decide if it's a vacation. This is a conspiracy. I mean, this took a lot of thought and effort. It's not a typical murder case. The defendant and her son set this up in a way that was designed to protect them. The main benefit of the structure of this conspiracy is that each party can insulate or distance themselves from each other. The primary risk of a conspiracy is that you're doing it with other people, right? You can get caught. Somebody can squeal. Somebody could give you up. And that's why the conspiracy is not shaped like this. Rather, they're not all huddled up together. They're going to be more like train cars. This is the way we see the communication flow throughout the course of the conspiracy. The best way to insulate yourself from your co-conspirators is to organize the conspiracy like a train car, with each car only communicating with the one in front and the one behind. That way, if someone gets caught or cooperates with law enforcement, they won't have enough information on you to give you up. And it's also very important to position yourself within the conspiracy such that those that have the most information on you are those most loyal to you. And that is exactly what Donna Adelson did. To be guilty of conspiracy, it's not necessary for the defendant to say any particular word or do any particular act. But in this case, she did do that. We have all those words and acts that we went over that directly tie her. They are direct evidence tying her to this conspiracy, plus all the powdered sugar dust. Don't let the way she thought she was going to get away with this be the way she gets away with it. Render a verdict that does justice. Find her guilty. Thank you.
Members of the jury, at this time, we are going to take our lunch break. The bailiff will take you into the jury room. Lunch will be provided for you. Once again, I'm going to remind you, do not discuss this case with each other until we have come to its conclusion. You may discuss any other matters, but do not discuss the case. Do not seek out any outside information. The bailiff will take you to the jury room. The lunch will be delivered shortly. Everyone can be seated. If the defense can go ahead and move forward with setting up the room in the manner in which you'll need to do. We will come back at 1:45. The defense will give its closing. The state will give any rebuttal that it has. 7 minutes and 6 seconds. Ms. Keppelman. You may request additional time if needed. Mr. Zellman.
With respect to us setting up, we're going to need the exhibits. The exhibits are obviously not going to stay in here during a lunch break. So once the clerk gets back from her lunch break, and we'll obviously come back a little bit early, but
Please return then by 1:20 so that way you can get set up.
thank you, Your Honor.
Judge, do you want the demonstratives that were admitted not admitted, but that were shown as demonstratives to be admitted as court exhibits?
Yes. If anything does need to be reviewed, anything that was presented to the jury, even as demonstrative, I'm sure will be of use to the appellate court.
Yes, sir.
All demonstratives for the state or the defense that were used during the trial, these will be court exhibits.
Yes, sir.
We're in recess. Defense is to return at 1:20 to set up. For everyone else, please return by 1:30.
demonstratives. Here in
The ones that are in evidence, yes.
Not in evidence.
It's not just the ones that are in evidence, Your Honors. It's also the other ones that we had requested to be put in evidence and submitted as court exhibits.
Well, these are items that are not in evidence. I believe the state's demonstrative specifically dealt with items that were in evidence as a part of its closing presentation.
I don't dispute that, Your Honor.
Or anything that is not admitted at this time that cannot be presented to the jury at this point as evidence for consideration or argument for consideration. The pages of the two calendars that are in evidence, you certainly can use. You can use the physical books themselves as demonstratives if you want to show the jury. Beyond that, getting into pages that have not been admitted and are not a part of evidence, what would be the proper basis of doing those?
Again, Your Honor, the way in which it's been presented is misleading. My client has, even if it's not a specific basis for admission of the rules of evidence, the Constitution allows my client to present evidence in support of her defense. And just based on, as I said, the way that the state has misrepresented items in the calendar, we would like to be able to present that as argument to the jury.
Again, at this stage, for items that are not in evidence, I do not find that these are specifically exculpatory. You can make any reasonable argument or inference as it relates to the admitted evidence, but items that were never admitted at this point are not to be presented to the jury.
Yes, sir.
You can bring in the jurors.
Your Honor, since we don't have a beautiful presentation as a state while Ms. Fulfer is giving the closing, I will be assisting by putting the items on display.
That's fine.
All right, jury entering the courtroom.
Everyone can be seated. Members of the jury, I hope you enjoyed your lunch break. At this time, we are going to continue with the defense's closing. Defense, you may proceed.
Good afternoon. It's been a long day. You've heard a lot, but I hope you'll stay awake so you can hear me too, okay? So, it's been what, 2.5 weeks, I guess, since you started this venture with us, and you've heard an awful lot. And I'd like to take you back to my opening statement. In my opening statement, there were some things referred to today that I'd like to address. The first one is that I stood up in my opening statement and said all of these wonderful things about Dan Markell, and then I called witnesses to attack him. That is not true. That is not true. In fact, the defense is the only part of this case that actually elicited evidence through testimony about the good qualities of Dan Markell. We elicited that on cross from his ex-wife, Wendy. And all of the things I told you in opening about what a wonderful man he was, a wonderful father, well-educated, successful, we elicited that testimony. And criticized today for having 2 witnesses who came and testified on the stand about the dissolution case and things that had been filed in it. That was not to attack Danny Markell. We didn't put that evidence on. The state is the one that made it an issue. They put those documents into evidence, the things that Mr. Markell had filed. So we're the defense, and we represent Donna Adelson, and we're just supposed to say, okay, well, they put it in, let's just let it sit there. We have an obligation to represent our client, and what happened in that divorce, whether it was contentious or not, was an issue the state brought up. They've been calling this a bitter custody battle for years. And they started this case by saying the same thing. So to have the people who were actually involved in the case point out that there never was a bitter custody battle is important, because there never was one. There was never a time when they were fighting over somebody having access to the children. In those pleadings, nobody says, you can't have them, I've got them. You can't have them, I've got them. When they filed their initial pleadings, they did what everybody, according to the lawyer who was on the case for Mrs. Adelson, meaning Wendy, on the case for Wendy, they all filed their typical pleadings. And in the beginning, you ask for certain stuff, and she asked for 5149, maybe for a tax purpose. But there was never one single time, and you can't be convinced that relocation was the issue where they were going to take Danny Markell's kids away from them. If you believe that, you are ignoring the evidence that the state of Florida put on against Donna Adelson. And when I told you in opening that this was all about theory and belief of what a motive was, and there was no evidence that a crime was committed by my client, Donna Adelson, that is exactly what has happened in this courtroom. The state is ignoring the evidence that came in through their witnesses that support our defense, and instead they stand before you with calls and text messages, and they tell you what they mean. That's not evidence. Their argument about what a conversation means is not evidence. You decide what it means. You've got it in front of you, and you have to consider it in the context of all of the evidence that's presented, not just what the state puts in, but what the defense puts in. And I know at some point when we were putting on evidence, you all were looking probably at me like, what are you doing? Who cares? Some of those little things matter, and I'm going to cover those in the defense, and you'll see why we put those things in that didn't seem like that I had a hoot to do with anything, because they actually did. Now, I think the state, near the beginning of the case, and I don't recall who the witness was, but near the beginning of the case, the state, through a law enforcement officer, elicited testimony about how this event transpired, this brutal killing of Danny Markell, how it transpired, and how they were able to break the case. And what did they tell you? They told you they broke the case because Luis Rivera, who was one of the killers, decided he would cooperate with the state of Florida in exchange for a deal, which for his crime, he ended up, the testimony was he got 7 more years for committing that crime. This is the man who got in the car, got the gun off the street, drove up to Tallahassee, Florida, stalked, is the best way I can describe it, Danny Markel in a car with his children from his home, watched him take his little boys out of his car and put them into the daycare center, followed him again to where he went to work out at Premier Gym, and sat in wait for him. Sat in wait for him. And then when Mr. Markel came out, trying to work some things out with his ex-wife, Wendy, about having the kids and who's picking them up at what time, even leaves her a really nice voicemail that they could get together and walk at the school to talk about the education of their older child, where he was going to be going to school because he was going to be starting kindergarten. And Wendy pushed back. You know, she pushed back. This was his time with his little boys, and she's telling him, no, you know, I've got plans. Well, it wasn't her time to do that. So leading up to his death, she's arguing with him over about an hour and a half worth of time that she thinks she's entitled to with the kids, but it's his time. And I agree with the state of Florida. The most important thing to that man was those little boys. And he fought for every minute he could get, and rightfully so. Then he drives home in his car while he's on the phone, and Luis Rivera, driving the car that's been stalking him all day, pulls up behind him in his driveway. Sigfredo Garcia gets out and shoots him twice in the head, and they pull off at a pretty high rate of speed and leave Danny Markel dying inside his garage. Left him to die. Those are the people that killed Danny Markel. Those two people. And the state has all kinds of arguments about how Mrs. Adelson's involved because she said these things about him, and we'll get to that in a second. But if Luis Rivera is telling the truth, what did he tell you when he got on the stand? What did he tell you? He said, and this is his signature on this document dated March 11th, 2025, when he was deposed, and those numbers and circles are his. And he testified to you that, where are my numbers? That Catherine Magbanawa, Catherine Magbanawa is the person that elicited Sigfredo Garcia to kill Danny Markel. Now, her versions change over time, so we'll have to address a few of those. And then she says she didn't even know Luis Rivera was involved. This is a woman who the state has admitted lied first time, second time, third time, fourth time, maybe the fifth time. Every time she puts herself under oath and swears to tell the truth, she's going to say more. She told you she didn't even know Luis Rivera was involved, but the phone records that were put in by the state of Florida prove otherwise. Because during the time that they're traveling to Tallahassee, when she can't reach Sigfredo Garcia, whose phone is she calling? On Luis Rivera. This woman can't tell the truth. But in any event, Luis Rivera then puts this number 2 next to Sigfredo Garcia because he's the one who actually killed Danny Markel. Number 3 next to himself because he's the one who got the gun and drove the car to kill Danny Markel and then away from the scene. This is the man that he says they killed. Who else on this document do you recognize? On this exhibit? Who else? Who else was involved in this? Well, all the players that the state claims are involved are pictured on this document. And he says, Wendy Adelson, she's the lady who wanted to get her kids back. This is why we were committing the crime. Wendy Adelson. And Doctor, the dentist, he called him, which is Charlie Adelson, who he identified, was the one with Katie. This one and this one are the reasons that they're coming to Tallahassee to kill Dan Markel. And I said, well, what about Donna Adelson or Harvey Adelson? No, they weren't involved. I said, would you put an X next to them if they weren't involved? And he did. Donna Adelson's name never came up, but Luis Rivera is telling the truth according to the state. That's who you're supposed to believe. And he says my client is not involved. There's some issues that I might address further, but I want to go through some of the things that the state stood up and told you. Relocation, relocation, relocation. That's the issue. That is the reason that my client had Danny Markell killed, because relocation was lost. Danny Markell was killed July the 18th of 2014. Relocation was done for over a year. That's the motive. It's been over for a year. And they said yesterday in court that the relocation issue didn't stop when Danny Markell was, when the divorce was over. It continued going on. The emails showed that. There is not a single email that's been put in by the state that shows that my client, Donna Adelson, was continuing on a rampage about relocation. The last email that they showed you today that my client wrote about relocation was July the 19th of 2013. The divorce was final on the 31st, said and done. They bring Wendy Adelson in here to testify. That's their witness. And she said it was done. Now, have Charlie Adelson and Wendy Adelson been honest with their mother? The evidence says no, they haven't been. Because the whole time Wendy Adelson is telling her mother, she's telling her mother that relocation is what she wants. She's the one who starts that. She's the one who asks her lawyer about it. The whole time in the spring leading up to this hearing, Wendy Adelson admitted in her testimony, she's sending these messages to her life coach and telling her life coach, you know, I think I want to stay in Tallahassee. But she didn't bother to tell her mother that. Her mother still thinks she's trying to get relocation. She does it in April. And then she writes to her again in May. I think I'm going to give up relocation. I can stay in Tallahassee. The kids will be close to their boys. There won't be any plane rides. And I like my job. It gives me all this flexibility. I'm going to stay. But she still doesn't tell her mother. She has her mother believing we got to fight for this relocation. She testified. Well, what I said, why did your mother get so upset? Well, she's venting to her mother about what she claims Danny Markell is doing. And she's venting to her mother about what she wants to accomplish, only she's not being honest with her. On the backside, she's making other plans. It'd have been nice for my client, Donna Adelson, to know that, because these emails that have been submitted here, which are proof that she wanted to have Danny Markell killed, would not have been written. And when she goes to her hearing on the relocation in June of 2013, she has her mother stay outside. Her mother can't hear what's going on in the hearing. She admitted she had several witnesses to call beyond the two that got on the stand. And then after the judge made the comment, she gave up. She could have continued with the hearing and put her witnesses on. The judge could have ruled against her, and then maybe she has an appellate issue. She gave up because she didn't want it anymore, but she didn't tell her mother that. When she told her mother, well, this is how the judges ruled, the mother understood that through the court system it was done, but not with her daughter, Wendy. Because you can continue to negotiate all the way through a final judgment. And that's what those emails say. They do suggest some crazy stuff. They do. But she puts in there, we're trying to negotiate. We're trying to negotiate. Get this, you can still work on this. She doesn't know when she's writing those crazy emails that there's no reason to write them because her daughter agreed. You know, you can have a dismissal on an issue. You can have a denial on an issue. She agreed to it with prejudice, which means it is over. She already made an agreement. She's not going to seek relocation anymore. So my client is hanging out there trying to support her daughter, and now she's sitting in a court of law charged with murder because of what she wrote in emails. Because the truth is, you are here to judge my client based on her conduct leading up to and to the time of death of Danny Markell. That's her conduct. Can you consider things she said and did after to see if it corroborates that she was involved? You can. But her conduct leading up to the day that Danny was murdered is in this book that the state has entered with emails. It's separated between, where you can see it, where they lead up to the divorce and then after the divorce until the time of the homicide. Now, my client did say ugly things about Danny Markell. During the divorce, she did, and the state has put them in. This is State's Exhibit 64. And they have emails going up through July the 11th of 2014. These are the bad names that my client called Danny Markell. During the course of a divorce where her daughter is constantly venting to her about what she says Danny is doing, she said some really bad names, and I'm going to say them, although you shouldn't say bad words in court. She called him some ugly stuff. The first one that they wanted to put in was from 2011. He was killed in 2014. They introduced this email from March the 28th of 2011 at 64A. And inside that email, they claim shows the hatred for Danny Markell. And you want to know why? According to their exhibit list here, because Mrs. Adelson referred to Danny's parents as, quote, the royal couple. And she and Wendy were bantering back and forth about some issues with Mr. Markell's parents. That's not hatred on Danny. It's not even hatred on his parents. We're sitting here with murder charges because she did something like that, called somebody a royal couple. She said other bad things. She called Danny a major fucker, Jibbers, which Wendy Adelson testified that she came up with that nickname for him, a religious zealot, and Wendy testified that the issues in their marriage included matters of he had now become more strict in their religion than she wanted to follow. That was one of their problems. She called him a royal jackass, a piece of shit, a fucker, crazy, a bastard, and she called him Elvis. That's why we are sitting here today. That is hatred for somebody. That proves they wanted to have him killed. Are you serious? You call somebody some bad names and that means you wanted them dead? My client has lack of any ability to stop herself from saying things. She can't do it. And I'm not trying to be offensive to her, but she can't. And all of these emails that they have introduced prove it. She is not a one-word person. She goes on and on and on and on. And they believe that she had Danny Markell murdered because she said some bad words. There's not a lick of evidence in here that they submitted of what she did prior to July the 18th, 2014, where she said not a single word that she wanted him killed. She was planning to have him killed. She was going to find somebody to kill him. She was going to pay somebody to kill him. She was going to kill him. That she was glad he was dead. That's not in here. And this is it. This is it. Before he was killed. You're judging her conduct before he died, up to his death. And that's all you've got. And I told you that in the opening statement. They have a lot of theories, and they like to spin evidence a certain way to make her look bad because she said ugly things. That is not proof of somebody having somebody killed. And that's it. Besides the relocation issue, which has been dead for over a year before he's killed, bad choice of words, I apologize. It had ended over a year before he was killed. Now they want to bring in something called the grandmother motion. This is what had to push her over the edge. Their own witnesses said she didn't know about it. Let's see who testified to that. Wendy testified, her daughter, that she never showed it to her and she never talked to her about it. But then there were two more witnesses for the state, and they were Craig Isom and Jason Newland. And when they testified on cross, they admitted that there was no evidence that that motion had ever been forwarded to my client. Not a single piece of evidence. What if she had gotten it? Do you want to know what it accuses her of? That a 3- and 4-year-old said that they called Abba, that she had called Abba stupid. Stupid. And that drove her over the edge. One, she didn't know about it, but two, somebody claiming you said the word stupid, that's what brings us to murder charges? It's unbelievable. But that's their spin that they want to put on it, because they've got this theory that she's the mastermind. And then they stand up here in their closing and they say, everybody who's been charged in this case, so they want to point at the other one, point at the other one, and point at the other one. No, 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 no. Who is pointing at these people? The state of Florida. The state of Florida is doing the pointing. They're the ones getting the warrants. They're the ones doing the investigation. They're the ones charging people, deciding who they're going to give deals to and not. That's them pointing the finger. That's not my client. There's no evidence of that. They bring the charges. They prosecute. They get the convictions. They get people sent off to prison. Not us. What? We're pointing the blame at the killers for killing them? They proved that those are the people who killed them. That's not us pointing the finger. They actually did it, and it's been proven. And we're distancing ourselves from Charlie Adelson. Let me tell you something. They elicited the testimony about Charlie Adelson over our objection, if you happen to remember that. It came in. Charlie Adelson is not on trial. You may be sitting in that jury room thinking, well, Charlie did it, and it sure looks like Wendy did it. That doesn't have an ounce to do with Donna Adelson doing a thing, not a single thing. If you think he did it, he's been convicted. He admitted in his testimony that he is the person, although he claims he was extorted, he is the person that took $138,000 out of his refrigerator size safe that he has at his house with the money exactly like he says he kept it, stapling $100 bills together in stacks of 1,000, staple, 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 staple. He said he took that money out of his safe and he gave it to Catherine Magbanowa that night. Whether that's his girlfriend and they're still fooling around on the side, that's between the two of them. That's got nothing to do with my client. He did it. But now they want to say Donna Adelson did it. Pick one. You don't like our theory? That's what they say. You don't like our theory? Oh, well, you like our theory on everybody else. Pick one. If you have prosecuted Charlie Adelson for paying the $138,000 stapled, just like their other witnesses in this case said, why are they now saying Donna Adelson provided the money? Oh, wait. Oh, because Catherine Magbanowa, who's been sentenced to life and is telling her sixth story now, has decided she'd like to see her kids someday. So now she's going to come in and provide information that will help the state prosecute an innocent woman so she can go home to her children. That's what that's about. So she claims that this all goes down. Charlie puts the money, Charlie, not Donna, Charlie puts the money stapled just like she knows he does into her trunk. She drives it the next day to Sigfredo Garcia, her baby daddy. He takes it out of the trunk, and a day or two later, she gets hers back. And she says he puts it in her closet, and to this day, she wants you to believe that that money sat in her closet and she spent it along the way. The records that Ms. Hull testified to, showing all her cash deposits, she clearly was doing something with it, right? But to this day, she wants you to believe she has absolutely no idea how much money she had. Never counted it. Really? She must have think y'all was born yesterday. But here's something. She's got this new thing she wants to testify to. That the money was wet, and Charlie told her that Donna had washed it. Her money's wet, that she hasn't touched, that's been somewhere else for these number of days. Well, what did Luis Rivera testify to about his money that he got? He said it was weird. Well, how was it weird? Well, it was stapled in $100 bills, stacks of 1,000. Not a single word about wet. And he got his money before she did. He got it straight from Sigfredo. This washing money wet thing is nonsense. And they've already proven that it was Charlie Adelson's money that was paid through Katie Magbanowa to those two killers. Whoops, it's gone. But now it's her fault. And I'm not sure what this is all about. The state standing up saying that the defense has suggested that Harvey is the one that did the Evite. We haven't said a single word, presented any evidence, or made any argument that Harvey Adelson is the one who created the Evite. Their witness that they called, Wendy Adelson, sat up there and said, what did she say? She probably did it because her mom doesn't know how. And then their other witness, Chris Corbett, Sergeant Corbett, who does all the media and cell phone tower stuff, he sat up there and he said it was clear to him from his research and investigation that my client, Donna Adelson, didn't have a clue how to work that. But she's responsible for sending out an Evite that Wendy says she did, where the names come up with guests who are going to be there that are Wendy Adelson, because she kept that name, and her two sons. So it's Wendy, the name of her two sons, and then Adelson at the end. If that's how it appears, Wendy did it, not my client. And there's more proof of that real quick to come. But the Evite thing is a non-issue. I just can't imagine what that is about. The state has argued that between the time the killers came to Tallahassee in June and the time that they came back in July and actually killed Danny Markell, that Catherine McBanawa said in her testimony that between those two time periods, when she was discussing scenarios with Charlie, he would say he had a call from his mother, step out, have the call, come back in and say, oh, they're stressed. Catherine McBanawa, not one single time testified to when that occurred, number one. Number two, if you've heard evidence in this case and paid attention, Charlie Adelson is not a one-woman man. He's got lots of girls. She doesn't know if that was really the mother on the phone. She doesn't know who he was talking to or what they were talking about. But she wants to get out of prison. So she's got information she's willing to share now. Charlie's business. There is a slide that the state had in its presentation this morning that they showed to you that shows that Charlie Adelson owned the dental practice up until 2015. Do you remember seeing that slide? Well, here they are again, ignoring the real evidence. They got a theory and they got to spin it some way, but the evidence from their expert witness, Mary Hall, financial investigator, forensic investigator, Mary Hall, she's up here testifying for them, and she says that Charlie Adelson was the owner of the Adelson Institute until 2020. And yet their slide says, oh, he sold it back to his father in 2015. That's not what the evidence is from their own witness. There was some argument from the state about some things that were in Mrs. Adelson's planner in 2023, around the time that Charlie Adelson was convicted, and they apparently were going to flee the country, take flight to a non-extradition country. And there's a notation in there shortly after Charlie is convicted that says cancel disability insurance. They want you to take what they believe that means as they were canceling their insurance because they were going away and never coming back. Could it be? Those were the words that were used. This is not a could it be situation. This is beyond a reasonable doubt. They have nothing other than that notation. Well, could it be that Charlie was convicted and he no longer needed disability insurance because he was going to prison for life? Just as likely. How about this? Could it be? Could it be in State's Exhibit 142 on the front page that they showed you, there's this little notation, notify everyone who was invited to the 70th birthday, that party is off if
That's what HJ decides to do. And that's on June the 13th. Could it be, the state says to you, that if the killing had actually taken place the first time the killers came up, then they'd be canceling the party because Danny would already be dead? What? Does that, where's the proof of any of this? Could that be what it means? This is not, could it be? And a birthday present. The birthday present, according to the state, for a 70-year-old man is that they're going to have Danny Markel killed. Happy birthday. Let's have a party. What? There's no birthday present, according to Rob Adelson. Wendy Adelson, who was at the party and who was involved, and there are emails that tell this, involved in helping get a caterer for the party where the man came and cooked paella out on the balcony for everybody. But that's what Charlie decided to give. But you got to read the worst in every single piece of evidence that they present to you. You have to, because that's the only way you can convict, and they want you to convict her. There's no evidence that there was a birthday present to Harvey Adelson to have this man killed. None. But that's their theory, and they're still spinning it. And you gotta ignore the witnesses that they put up there in order to follow their lead into that jury room and convict my client. Let's talk about Rob Adelson. They brought him in here, and he got up there and he testified on the stand about allegedly all of these things that he claims his mother said. If you were paying attention by the time we got to cross-examination, what did we learn about Rob Adelson? Well, he's a doctor and he's got little kids, so he's real busy, which is his explanation for why he rarely speaks to his family on the telephone and has, in that time period, only been down to see his family 2 times in a 2.5-year period. And he rarely talks to them on the phone, but somehow Miss Adelson has made all of these comments. This is a guy with an axe to grind, right? He doesn't have any of this information. He's not talking to them. They got him to come for the birthday party, and what was his testimony? He's a busy guy. He flew in the night before the birthday. He was at the birthday party and got up the next morning, packed his bags, and put him and his wife and his kids on an airplane and left because he was busy. He's not hanging out with his family. He's nowhere to be found. Oh, but you got to believe everything he tells you. A huge percentage of the argument of the state was, well, what did Rob say? What did Rob? Rob doesn't have the knowledge of anybody. He's not here. He lives in Albany, New York, and he's not around these people. But let's use her son, who's clearly estranged from the family, to try and bury her. You're smarter than that. So my client has been charged with the murder of Mr. Markel, conspiracy, the planning to commit murder, and solicitation, hiring the hitman that killed. We're going to go through the jury instructions briefly. The judge has already gone through them, but we're going to go through in a minute what actually is there that the state has to prove. And just like I said in opening, what the state thinks happened does not matter. What they believe happened does not matter. What spin they want to put on it does not matter. You can only make your decision based on the evidence presented to you, and up through the time that Dan Markel was killed, that's all they got. She said some ugly things, and oh, she meddles in her children's lives. Meddles in their lives. Gets involved in their divorce. She's a parent. She's just being a parent, not a killer. She's a meddler, not a murderer. They haven't proven that to you. Just like I told you in opening, what they were going to be able to prove, and that what you were going to hear a lot of evidence about, lots of introduction of exhibits was going to come in. They proved that those 2 men killed Danny Markel, that Catherine McDonald was the one who found the killers, that Charlie Adelson is the one that paid the money. That's it. Oh, and Wendy Adelson is the one who wants to get her kids back. That's why they're killing him. Nothing about Donna Adelson. We sat here for days listening to testimony of witness after witness getting on this stand. Not a single one of them connected my client to Danny Markel's murder. Not one. I think the state introduced a couple of exhibits. They would be 64C and F. Sorry, I can't do technology. Somebody has to help me. And these are emails where she's giving her daughter advice on what she should do, preparing for mediation. Oh, how terrible of her. But what they didn't want you to see in this email, do you see that highlighted part? If she thinks she's going to have him killed, why is she telling her daughter in mediation, make sure in the final order that he has to pay half of this expense and half of that expense and extracurricular activities and tennis lesson and baseball teams and travel? Well, who cares if they're going to kill him? Why is she writing that? Negotiate. Negotiate. Shame on her getting involved in her daughter's divorce. Negotiate. Let him know that you want him to see his children. And they talk a lot about this bribe. Bribe. This man, they were considering giving him $1 million to relocate because he had already lived in Miami with Wendy. Relocate back to Miami. He taught, according to Wendy, 2 days a week. He could commute by airplane. They were willing to pay for plane tickets, give him money to buy a house, expose his children to a more strict Jewish environment where they had Jewish schools and all kinds of activities and be around more kids, kosher like Danny. Relocation was never about taking those kids away from him. It was, how can we make it happen? You can live in the same city. We can co-parent separately, but be together, be around each other, and all have family support. Shame on them for wanting to help him like that. They act like they were doing something illegal. That's not illegal. You heard the woman testify. It happens a lot in divorces. People offer money to get certain things that they want, or they concede something they're entitled to. But if Mrs. Adelson does it, she must be up to no good. This grandmother motion, I want to point out something to you for just a second. That would be 60JJ. The state calls this the grandmother motion because they're prosecuting grandma. Sounds kind of cool, right? There's this terrible motion, this grandmother motion that was filed against my client, Mrs. Adelson. This pleading is actually entitled, let's see here, former husband's counter motion for enforcement of MSA, which is marriage settlement agreement, on parenting issues, and motion for contempt and sanctions. And this pleading goes on and on about, he says Wendy's refusing to facilitate video teleconferencing with the 3- and 4-year-old, that she's failing to regularly facilitate telephone contact with the children, that she routinely violates the right of first refusal, resulting in the children missing days from preschool, that she violates her duty to inform that's in the MSA. She fails to follow clinical recommendations. She violates by refusing to communicate with Mr. Markel. She persists in inhibitory parental gatekeeping. Refused to provide access to have both children on one of the child's birthdays. The only single complaint he makes about my client is she called him stupid, according to a 3- and 4-year-old. And Sure, I can do this, but I'll try. Number 6, this is the section. You can write a motion and put all your complaints in it, your legal argument, and then you ask for what is the relief that you want. He wants all kind of relief related to Wendy. And this is what they say. The state says that he's saying that the grandmother cannot have any unsupervised contact with the children. That's not what it says at all. It says consistent with the right of first refusal. And safeguard the children so she doesn't call him stupid anymore. This does not mean she can't have unsupervised contact. It means consistent with the right of first refusal. If grandma's in town and she's going to watch the children, according to their marriage settlement agreement, he has to be given the opportunity first if he wants to take care of the kids. That's what was agreed to in the divorce. That doesn't say no more unsupervised contact with grandma. Now, besides her not knowing about it, what is the evidence? I don't want to mess this up. What is the evidence that supports two things? One, that my client did not know it had been filed, and two, that Danny Markell was not trying to keep my client from having unsupervised contact with him. Well, the proof is from Wendy's testimony that he continued himself, because during the course of the marriage and separation and divorce, my client, Mrs. Adelson, didn't just continue to assist Wendy when Wendy needed help with the kids. She continued to assist Danny. And in fact, that motion was filed on March the 26th, and the testimony was for almost 2 weeks in April, my client watched the boys while both parents were out of town. And my client facilitated the Skype with the grandsons for Mr. Markell. Now, if he's really worried about her having unsupervised contact, is he going to leave him with her for almost 2 weeks in April? And he does it again and again. And the last time that he does it is on July the 11th. That's according to Wendy. He comes home and he needs help. She's going to go do something. And then now it's his time to have the children. So he asked my client, Mrs. Adelson, if she could watch the boys. And she does. And she knows he likes this particular kind of banana bread that she makes. And they're going to mock us for this, but that's okay. He likes this particular kind of banana bread. It's got chocolate chips in it and no nuts. And so what did my client do? Before he came to pick up the boys the next morning, the evening before, she makes him a loaf. But she hates him. She hates him and she wants him dead. And clearly he hates her because he filed a motion. It's unbelievable. Us sitting here is actually unbelievable. Now, I want to talk about the day that Danny was killed with respect to my client. We're not going to go through all the details again, but what is the evidence about my client? The state has said that my client tried to set up an alibi for her daughter. I don't know how it could have ever been considered an alibi because the man was going to get there at 8 o'clock in the morning, and the evidence is he got killed around 11 o'clock. But State's Exhibit 64FF is from the Geek Squad. And the state presented earlier that not only did Donna Adelson send an email to Wendy that morning, or before then actually, not only did Donna send an email to her about the appointment, but Harvey, the dad, did as well. And here is the form that was completed, not by Donna. They say Donna arranged it. Mr. Harvey, this appointment for the broken television. They had purchased a plan for protection on this television and believe they may get a replacement or a repair. When they made it, you have to fill out some information on the form. And what does this say? Would you be willing to accept a sooner appointment if one became available? Yes. Well, now, are you going to accept an earlier appointment if it becomes available? If you've got a homicide plan? That doesn't make any sense. This is supposed to be her alibi, but they're agreeing you could come earlier if you want. And then the mother sends an email. Do we have that? And what she tells her daughter is, if you can't keep Friday, July the 18th, between 8 a.m. and noon. Call that number to reschedule. The contract is under Harvey Adelson's name with Dad's cell phone number, but the purchaser is actually Miss Donna's name and cell phone number, and she provides her with a work order. Here, we did this for you, like we do everything else for you, and apparently that's a bad thing according to the state, helping your kids this much. But here, we helped you out, but if this doesn't work out for you, change it. A fake alibi, that's what they want you to believe. You got to read bad into every single thing they present to you to come to the conclusion that they come to. Now let's talk about defense exhibit 71. There was, according to the testimony that you heard from the state, Wendy Adelson was interviewed at TPD the day that Danny was killed. They went and found her at a restaurant, and they've introduced these pictures about what she did that day and where she went and how she took the long way around. But she's sitting at TPD being interviewed, and she has requested to be able to call her mother. And unlike other exhibits where the state hired someone to enhance it so you could hear the call better, they didn't do that in this case. And the recording is actually inside the room. You can see it. It's an interview room at TPD. And not only are you hearing what Wendy is saying, there's the victim advocate that testified that my client was shocked when she heard the news. But my client is actually on the other end of the phone, so it's not real easy to hear. But if you put the headphones on, you're actually going to hear some things, and you can hear what my client's reaction is to finding out that Danny Markell has been shot, excuse me. Can we play that? If you could just please put your headphones on. It's not easy to hear. Am I here?
Maybe just sit down. I'm fine, and the boys are fine. Danny has been. You can put me on speaker. Yeah. Danny has been shot. And I don't think he's gonna make it. And so I know. So I found this out around 1 or 2 today, and I'm at the police station, and I'm trying to help them figure out who may have done this. The boys are fine. I had Lynn and Ellen pick them up from school, and they're with Lynn and Ellen right now. And I'm gonna leave here soon and go be with them. But I really need you to come here and be with me. But I want you to either fly, and obviously you can't leave right now, but I need you to get yourself together. If it's too much to drive, I'd really rather that you flew up. I'm at the police station, and I'm gonna leave soon and be with the boys before they go to bed. They're with Alan and Lynn, and they're totally fine. Yeah, the boys are fine, but they don't know anything yet. In his house, I know. I know. So I just need you to calm down before you get in the car, okay? Okay, so, and it's, it's evening, so if you want to come here tomorrow, I have a lot of people that'll, be here with me, and, we'll have a lot of support. So I want you to take your time and just be safe in getting here, but I'd like you to come when you can, okay? Okay, all right. I love you. I think Jane might, I have the car here, but Jane might take me. I'm not going to be alone, so I have a lot of support, and I'll be fine. But But, yeah, if you could just come here, that would be great. He's in the ICU in the hospital. Okay, but be careful, okay? Okay. Okay. Okay, love you too. Bye. Mom.
I haven't actually put the headphones on, but hopefully that assisted you in hearing. But like the victim advocate for TPD testified, she was shocked. She's not sitting home waiting for a phone call. Let us know that it's done. It's 7 o'clock at night, and Wendy's calling from TPD to tell her mother that Danny has been shot. She has to tell her to calm down before she gets on the road, and you can clearly hear her elevated voice. She's asking about Danny. How did it happen? Where was it at? Well, where's he at now? He's at the hospital. This is not somebody who's planned for him to be killed. Now, the state has made a pretty big deal about the road trip that this 70-year-old man and 64-year-old woman take that evening when they leave their home. It's 11 years into this case. It's this July that just passed before the investigator in this case, who's given testimony again and again, after he's deposed, decides, I'll go ride the route. 11 years. They've been claiming now, my client, arrested almost 2 years ago, that this ride is completely off, but they haven't even tried it themselves, right? And even when he testified, and also when Agent Sanford testified, first of all, he didn't do the whole route. He did a segment because he's determined that in this segment is where Mrs. Adelson was at for too long. Did you take any snacks when you did the ride? And he's only doing part of it. Well, yeah. Did you get some coffee? Yeah. But they've calculated this drive for these folks who have just received horrible news and they're clearly upset about it, that they had to be at their son's house dropping off money that was washed because there's a period of time that it takes them longer to get to their hotel in Orlando than it should have. They took into consideration nothing with respect to their age, that they hadn't had anything to eat. They didn't calculate any time in to stop and get gas or to use the restroom or to maybe sit down and have a meal. None of that's counted in. It's got to be a strict from here to there, and you're not there, then you must be doing something bad, and it must have something to do with murder. They give no consideration to that whatsoever. But what's stronger than that is their own testimony from their expert. They have all of these slides that they've shown you where they can show where everybody is in the entire world. And did you notice that for the killers, they had collected records with SunPass and cell towers, etc. And they have a whole map that they're showing you where they went and what they got. They got the SunPass records for the killers. Agent Sanford said that my client was a person of interest from the beginning, but he had her locked in a year. And yet here we are 11 years later, and they never bothered to get her SunPass records. They can get them. They got the killers. If they want to tell you that they're stuck in a certain area and they've gotten off in a certain place, all they had to do was get those records. But they didn't do it. They can prove where the killers are, but not my client. But one thing for certain that they did say is they cannot put my client's phone at Charlie's house during this time period that they say that they took too long to get somewhere. They also testified that there is never a point in time that evening where Charlie's cell phone is hitting on a tower and either Harvey or Donna's cell phones are hitting on the same tower. They don't even have them in the same vicinity, much less the house. But they want you to believe that means Mrs. Adelson was there dropping off money. They have no evidence of it. It's just their theory. That's all it is. You can't convict somebody based on theory. You have to have evidence beyond a reasonable doubt. Now, how about this text message that says outside your house? According to them, outside your house means outside your house. I'm not saying that's illogical to jump to that conclusion, but do you have any evidence of it? No, they can't put her there. And according to State's Exhibit 142, if Mrs. Adelson was at Charlie's house, what in the world is she doing hanging outside for over 30 minutes before he gets there? She's got the garage door code to get in, but she's outside the house. They introduced this. She had talked to him according to their records. She had been on the phone with Charlie. She talked to Charlie. And then later on, they send this text message, and it could mean many different things. But it would have been 30 minutes while they were waiting there for him to get there. And there's no reason for them to be outside the house because they know he's not there. It took him 10 minutes to send, or 20 minutes to send a message back saying he was 10 minutes away. And then he had to travel there. They don't have proof that she went there. They want you to envision it and imagine it and believe it because that's their narrative. That's what they tell. And I don't think I said it before, but the witnesses, the additional witnesses that testified that Charlie kept his cash, these $100 bills stapled together, that was Miss Umchinda and Mr. Fitzpatrick. They both testified they knew Charlie well, and that's what he did. No evidence at all that my client did that. Do you remember back in jury selection? I didn't do it for Miss Adelson. My co-counsel did, Mr. Zellman. But he asked you a series of some similar questions, and he asked you, would you agree that the state could make a mistake in the theory of their case? Yeah. Would you agree that law enforcement could make a mistake in their investigation and determining who they think committed a crime? Yeah. That was the overall response that we got. It was asked of everybody who came up that got individual questions. I mean, questions as a group. Well, according to Special Agent Pat Sanford with the FBI, do you remember his testimony? According to him, he has never made a mistake. Not one time in his career has he ever thought somebody committed a crime and he ended up being wrong. You know what the problem is? When he thought she was a person of interest from the beginning, and then he, according to his testimony, locked in on Donna Adelson, the path didn't lead to Donna Adelson. They tried to build a path with something as flimsy as these emails that they say are the motive for her to have him killed. They made some other mistakes. Rob Adelson calling him to testify was a mistake because they've clearly relied on his evidence, and he testified himself. He wouldn't have the basis to give it. He's never around. And then they called Patricia Bird. That's their next mistake. She claims, different ways, that Donna was going to buy her some land and a trailer to put on it, a small car to drive, and fix her teeth to testify untruthfully. She said that a white female investigator actually offered her all of those things. But then when it was pointed out to her that the investigator that came to see her was actually an African-American female, oh, it was her that did it. Then she wants to tell you that my client confessed to her. I asked her, did she do what they said you did? And Miss Donna said yes. Well, she's not clear on this confession because when Mr. Zellman was asking her questions, she couldn't remember if it was Donna said she wrote the checks or she confessed to the whole crime. But here's a woman sitting in front of you that has come up all of a sudden at the end of the game And here she is claiming that an investigator offered her these things and that was for false testimony, that Ms. Adelson was trying to elicit false testimony, have her come in here and swear under oath and testify to things that were not true. Well, both investigators came in here and said that never happened. She was never offered anything. She never told us that Donna had offered her anything. Most importantly, she never told us that Donna confessed. None of that. She's facing going to prison, and she has an opportunity to come in here and testify against Miss Adelson so she can get a deal. What was she facing, 5 or 6 years? Here's the biggest part. Did you hear what the judge read to you this morning before he started with the jury instructions? He read to you a stipulation. As he explained, that means the state and the defense agree to certain facts, and you must accept them as true. And what was the stipulation? Patricia Byrd was never on the witness list for Donna Adelson. Well, isn't that interesting? She was going to come in and testify falsely for Donna Adelson, and she's never been on a witness list. And then you got Drina Byrd. This is not just someone who is hoping for some help in her case. She already got it. Her testimony was she is a 27-time convicted felon and or crimes involving dishonesty, facing 15 years in the Department of Corrections as a prison releasee reoffender, which means you get day for day with no gain time. Here she comes saying she's got all this evidence, and Donna's offering to do the same things for her that, oddly enough, Patricia Byrd in the same cell block has said is going to happen. What does she do? We tried really hard not to bore you by playing the whole tape, but there's an exhibit that we put in, and it's the video of where Donna and Miss Bernhardt are sitting at a table. Oddly enough, Miss Byrd wasn't there, and she told you that she was with Donna Adelson day and night talking about her case. She wasn't anywhere around when they're sitting at this table, but you can watch that video again. I would just like you to recall this. Who shows up to that table first? Drina Bernhardt does. Who shows up with paper and a writing instrument? Drina Bernhardt does. And while they're sitting at the table, is Donna sitting there just telling her? No, they're having a conversation. How does the writing start? Miss Bernhardt gets out her little hot pink folder, paper, whatever it's called, notebook, plops it open, shoves it towards Donna Adelson, and starts tapping on it. Let's get busy writing. You don't hear those words, but that's what she's doing. Here, right. And allegedly, she's going to do the same thing, give false testimony, and her name is not on a witness list. A little bit more about Catherine McBanawa. No, actually, I covered that. So if this is all they got, up until the time that he died, just that she said bad things about him and helped her daughter with her divorce, what is the evidence that they have after Danny Markell was killed? They put this evidence in. They got nothing to show that my client was involved in any way leading up to the time that he was killed. But they elicited the testimony that it was 2 months after the murder when Charlie Adelson discloses for the first time to his mother what he knows about the case. Now, all she knows is what he's telling her, but it's 2 months after the murder when he's telling her, well, what happened was I got a girlfriend, and I had told her about this $1 million offer, and she said it in front of some of her friends, and they've gone up there and killed Danny Markell, and now they're demanding money. And so they said, if I didn't turn over my third of the $1 million, this is what he claims that they elicited. If I didn't turn over that money, then I'd be dead in 48 hours or they'd kill my family. So he goes into his safe and pulls out $138,000 cash, puts it in a bag, gives it to Katie, tells his mother 2 months after the homicide, now he's being extorted. She works at Adelson Institute. They want you to believe this is a family business. Does family work there? Clearly. But who owns the business? Who does the money belong to? Who is Mrs. Adelson writing and paying all the bills for? Who's she doing the salary for? Everybody there. Everybody there. So he tells her, write around $1,000 a month to Katie Magbanawa. It'll save my life. They had this forensic investigator and they didn't present anything to you, not a single check ever that Charlie Adelson signed for his business, because he had his mother paying the bills, doing salary and other things at the dental office. That's him paying these people. She's doing her job because he says it'll save his life. She believed it was the truth, so she did what he told her to do. Was there pushback or not? We don't know. They didn't present any evidence about that. They claim she would have pushed back. Maybe she did. We don't know. But what we do know is it's 2 months after the murder before she knows what has gone down. That's their evidence. But she conspired with people to have him killed. She got the hitman to have him killed, and she wanted him killed, and he ended up dead. She doesn't even know about this going on. And the only version she knows is what her son has told her. Did she say, oh, the truth's coming out, the truth's coming out, the truth's coming out? She did, because that's what Charlie had told her the truth was. And that's her son. And she believed him. And she didn't want her son to die. She wrote paychecks at Charlie's instruction. That's not her giving cash and paying off murderers. That's a paycheck to Katie. That's it. That's all she did. So we're bumping along, and now we're in 2016, and it's a bump. Law enforcement testified to you that they created this scenario where they could try and get information to further investigate this homicide. So they've locked in on Mrs. Adelson, so they're going to set her up. Funny thing is, Mr. Sanford testified to what probable cause is that you have to get a wiretap on somebody's phone, and you have to have proof that a crime has been committed, and this is likely the person who committed the crime. It's not proof beyond a reasonable doubt. It's the same that you have to get a warrant to arrest someone. But when they do this bump in April of 2016 to June, who do they get wiretaps on? Charlie Adelson and Catherine Magbanawa. Not Donna Adelson. But they're just sure she's the mastermind behind this. So what do? They follow her. They watch her daily routine. They pick a location where she is taking her grandchildren, Mr. Markel's children, to and from school. And they decide that's where they're going to do this bump. This is State's Exhibit 113 of the bump on the street that took place on April the 19th of 2016. Am I in anybody's way?
Black choice. What is it? Okay, I get that. Excuse me, Mrs. Adelson? How you doing? Just want to give you this. Listen. No, don't be scared. Listen, just want to let you know that, you know that your family, has been taking care of Katie and her friend Google for quite some time after your problem of more than charge. And I want to let you know that my brother, he's incarcerated. He helped your family with this problem you guys had up north. And we want to make sure that he's going through some rough times. We want to make sure that you take care of what he's going through, the way you're taking care of Katie and Tuco. Well, this will explain it. Thank you.
What did she say? You scared me. And he goes on his little explanation, and her response is, I don't know what you're talking about. Now, the state says from what happens next, which is a phone call that Mrs. Adelson makes, she has to be involved in this murder because she doesn't call the cops, she calls Charlie. Well, why'd she call Charlie? Because Charlie has confessed to her his role in paying the killers back in September of 2014, that it's his money, claiming he's being extorted, claiming his life is at risk. That's who she's going to call, because guess what? Now this man is talking about the people who are involved in the murder. You're taking care of Katie. So yes, she calls. And the state wants you to believe that there's this huge made up code. They allowed you to look at the transcripts when that was going on. And you looked, I watched, you were all intent looking at the transcripts and listening to the calls. If you go back and want to hear them again, you're welcome to do that. She's responding to his questions and his instructions not to talk about this on the phone, but he keeps pushing and pushing and pushing. So she's trying to give him a hint without actually saying on the phone what's going on. These are hints, not code words like the state wants you to believe. Can I have just 1 second, please?
Members of the jury will take a brief break at this time. If you need to use the restroom, please do so during the break, and we will continue with the closing argument. Everyone can be seated. If you need to use the restroom or stretch your legs, this is your opportunity. Or something to keep yourself from passing out. This is your opportunity now. 5 minutes. let me get the timer back in the correct position. everyone can be seated. Ms. Fulford, you may continue with the defense closing argument.
As you recall from the testimony, there was a meeting between Charlie Adelson and Catherine Magbanawa after the mother had after the bump, right? Do you have that? There's a transcript of that. You can't make out everything they say, but this is part of the transcript that I wanted to point out to you. This is Charlie Adelson talking. Don't waste your time with mom. They need to talk to someone who's first person. Wouldn't it make sense that they make a connection to my family, to me, to my family, not my mom? And then he says to Katie, "You're the office help. Checks are on me. That's just because they found out you come in and work on the weekends. Trust me, I'll keep you on full time, so you're going to get your checks." That's Charlie Adelson agreeing that he's keeping her on payroll and the checks from him will keep coming. After the bump on the street, Mrs. Adelson receives a letter. And the statement from, or the evidence that came from the state's witness, you recall that he said that his instructions on when he met her on the street was to be polite. This is not so polite. The next thing, she gets a letter and it says, "So my phone is not ringing, so you don't care about Tato and what he did for you. He knows he is fucked and soon so will you." Now, it doesn't say I'm going to kill you, but now the threatening behavior is coming and they're taking the next step to try and get Mrs. Adelson to come out and admit to something. If she pays the $5,000, bingo, right? She doesn't do that. So that happened on April the 26th. Then she does nothing still. She's scared, and you recall from the phone calls, she's scared. She thinks it's someone related to the killer. She's worried about her safety. She thinks something bad is going to happen to her, but Charlie just keeps saying, "Mom, everything's okay. You have nothing to worry about." Then on May the 4th at 2:09 in the morning, the undercover sends her a text message, 2:09 in the morning. "So you don't take me serious. You think I'm playing. You have some puta call me to see if I'm for real. If you think what Katie baby daddy did for you can't come back, you're fucking crazy. I want the now or I'm going after the 100K. So threatening, "I'm going to go to the police. This is not going away. Don't think that I'm gone. We're still here and you're going to do something about it." That happens on May the 4th. As you recall from going through the wire summary with the state, other calls take place in between. And then on May the 6th, finally, Donna calls the undercover at the number that he had provided initially, that shows here on State's Exhibit 83 with the article about Danny Markell being murdered. Call or text, that's the number that was provided, 305-712-6570, and the dollar amount of $5,000. Now, the state has said to you, innocent people don't fold the paper up and put it in their pocket. I'm pretty sure there's not going to be a jury instruction that tells you she must be guilty because she folded it up and put it in her pocket. She took it very seriously. She got her grandchildren, she went home, and she immediately called Charlie to report that. But now she's calling the number that was provided, and you've heard from the testimony, she downloaded an app so it could be recorded, but of course it was being recorded by the undercover as well. Could we play that call? And I think we have provided a transcript to you because it wasn't provided previously, if you'd like to read along.
This is Mrs. Adelson. Is this, Daniel? Okay, my grandchildren had my phone before, so,
Senora Adelson?
I'm Mrs. Adelson.
Yes, yes.
My grandchildren had my phone before, so that's, and I just saw that you called.
Oh, okay. You left a message on my voicemail?
Right, I did.
No.
This is my problem. You approached me on Alton Road. You handed me an article from the newspaper about my ex-son-in-law. You told me I need to call you and help your friend who is in prison. Now, at the time you did that, I didn't understand what you were talking about. I didn't call you back. Then you mail me a threatening letter. Then you send me a text message to my phone that says I'm not taking you seriously. So I am taking you seriously. And I really want you to listen to me. I have to tell you, I mean, this is important. I have been so stressed out. I have spoken to 10 or 12 people who are close friends of mine, telling them about this and basically picking their brains and asking them what I should do, because I don't know your friend who is in jail. You mentioned a name. I don't even know his name. I never spoke to him. I don't know what he looks like. I've never met him. I'm sorry your friend's in jail, but I don't know what that has to do with me.
You know exactly what it has to do with. You know exactly what it, listen to me carefully. Listen to me. You just gotta listen to me.
You need to ask who this person looks like, what their name is, something, because I know there's a big reward out there, and if you need money for your friends, that's the way to get it. I mean, I'm asking you nicely. I don't know who he is. I am out of the loop. It is not me. If I can help, I would help. I mean, that's what.
Just like I told you, listen to me. Just like I told you that day, we know that your family had a problem up north. We know that problem was taken care of about 1.5 years, 2 years ago. And we know the case has been taken care of and has been taken care of. Now my brother in jail, we were in Broward together. He told me the whole thing, and he hasn't been taken care of. You know. Now, all that's being asked for is 5K. That's all we're asking for is 5K. And he told me everything, and I know everything. I know who's involved. I know everything, and I'll get the 100K for myself.
You know,
all I ask is to send the 5K. Everybody knows what's going on.
You're saying everyone knows. I know I lost my ex-son-in-law. I did not have anything to do with it. That's why I said, ask him what.
That's what my brother Tasso told me. He told me everything when we were in jail. He told me everything and who was involved. I know everything.
I don't. That's the problem. I'm telling you, it's not me. It's not me. I have had a year of aggravation, 1.5 years of aggravation over this. My daughter, my grandchildren. It is not me. And when I asked my friends, what do they think? They said, well, this person needs to get a description of you because of what you look like, or it's not me. I don't know who caused this. It wasn't me. I mean, I don't know.
I'll tell you, just like that day when I spoke to you, this is not going away. This is not going to go away. Because Tasso told me everything. He wasn't being taken care of. He needed the 5K. Spend 5K. That's all we were asking for. Don't do that.
I don't know who Tasso is. You don't understand.
We know you don't know who Tasso is, but you know who Katie is. And you know the contact Katie has. And she has, listen to me, let's stop fucking around. Let's stop fucking around. know that Katie has somebody that knows stuff. And they took care of a problem for you people. That's just the bottom line. The bottom line is you know who the fuck Katie is.
Look, I don't.
I'm not fucking around with it. You know who Katie is. You know that they took care of Katie and her people. Nobody's taking care of Tato. I know you don't know who Tato is.
No,
But we know who all of you are. And this ain't going away.
you know what?
So I can give you that, you want to spend the 5K?
Here's what you need to do. You need to go and.
Don't tell me what to do. I know what to do and I'm doing it.
You're looking for money, get $100,000 or whatever whatever the reward is. It isn't me. You have got the wrong person. That's why I said, ask your friends,
You're Donna Adelson.
Yes, I am. Yes, I am.
Well, I know, we know who's involved in all this.
This is not making any sense. I mean, if you want the money, you should get it from the police. They can give you a whole lot more than you're asking me for money for someone. I can't do this. I have had too much stress and too much aggravation from this, and I don't know what you are talking about. I just don't know. I just don't know.
Good, I think you should talk to Katie, talk to people that are involved in this. You'll know, you know what's going on.
That's why I'm.
You can tell me, you can tell me all you fucking want, but I know you know. Because I know, because I heard, when I was locked up in Broward with my brother, he told me everything. Everything. He told me everything.
Well, then
I just wanted to take care of him because fucking Katie was being taken care of with her fucking people.
I just think instead of asking me, you should get the money from the police. There's a lot of money out there, and I know, if you think you know who this is, then go ahead and do it, because I know it isn't me. I know it isn't me. And I can't take this kind of level of stress. I just can't. I know I didn't do anything.
To talk to people, you talk to the right people, you talk to people, you make this 5K come to me. That's all I need. Just do it and get it to me. Do it and get it to me. Bye.
They tried 5 different times. I'm sorry. Did you want a particular position? Yeah. Sorry, Judge. 5 times they tried. They tried to get her to pay the money. They tried to get her to admit that she was involved in this. And 5 times it failed because Mrs. Adelson tells them in this call, he keeps telling her, I know everything. I know everybody. I know what happened. And she tells him in this call, if you know, go to the police. Go to the police and get the reward. Why in the world, if she's guilty of committing these crimes, is she telling somebody who apparently knows everything to go to the police? If you're guilty, you're not sending anybody to the police. That's why they think they can get her with the 5K. But she didn't do it. And still consistently, Charlie is saying, nothing to worry about. Don't worry. You can hear the fear and worry in her voice on that call. Now, the state talks about coding and code words, and one of the things they say is that in one of the discussions with Charlie, Mrs. Adelson says, it's about the 2 of us. It couldn't be more clear what that means. Her son told her in September of 2014 that he got extorted. He has to pay this money. He has paid the money, and he's going to keep paying the money so he doesn't get killed, right? Now somebody has walked up to her on the street about the exact same subject, Mr. Markell being killed, and demanding $5,000 from her. So now he's brought her into this. It is the two of them. They're not knocking on his door. They're coming up to her on the street. They're sending her text messages. They're sending letters. They're calling. They won't stop. But she didn't do anything. If her son did, that's on him, not her. There's no evidence that if Charlie Adelson had not told her in September of 2014 what he told her, there's no evidence that she would know anything at all about what happened. That's her single source. And he brought it to her. Bring cash. That's one of the things she says. Bring cash. Without telling him what has happened on the street, she's telling him they want cash. That's not code. That's hint, hint, hint. You don't want to talk on the phone, but you won't stop asking me. So I'm going to hint to you what this is about. There's nothing code about that. The state is interpreting what they think these things mean. It's not their interpretation that matters. It's the evidence that's presented. The judge has read you the jury instructions. So I'm not going over all of them with you, but I want to say this. Murder in the first degree, the state has to prove that on July the 18th of 2014, Donna Adelson intended that Dan Markell be killed on that date. They have to prove that. There's no evidence of it. First degree murder is killing with premeditation, is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The premeditated intent to kill must be formed before the killing. They've got no evidence of her doing anything until after Mr. Markell is dead, when she writes the checks at the instruction of her son. Conspiracy. The state has to prove beyond a reasonable doubt that the intent of Donna Adelson was that the offense of first degree murder would be committed on the date that he's killed, not after the date, before and up to the time that he shot and killed. They have to prove beyond a reasonable doubt that she had that intent, and they have nothing. Solicitation to commit first degree murder. They have to prove the following two elements beyond a reasonable doubt. I'm sorry, back to conspiracy. I forgot to say this. In order to carry out the intent, Donna Adelson had to agree, conspire, combine, or confederate with Charles Adelson or Catherine Magbanawa or other persons to cause the first degree murder to be committed. Had to be before, no evidence of it. Solicitation, prove the following two elements beyond a reasonable doubt. Donna Adelson solicited Charles Adelson or Catherine Magbanawa or other persons to commit first degree murder. During the solicitation, Donna Adelson commanded, encouraged, hired, or requested Charles Adelson or Catherine Magbanawa or other persons to engage in specific conduct which would constitute the commission of first degree murder. What does solicit mean? It means to ask earnestly or to try to induce another person to engage in specific conduct. We know that the state has not presented evidence of Mrs. Adelson actually shooting and killing Dan Markell. They are asking that you find her to be a principal, that these other people did the killing, but she's a principal. And to prove that she's a principal, you have to show that she helped another person or persons commit the crime. In doing so, the state has to prove beyond a reasonable doubt that the defendant intended the crime to occur and the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. For first degree premeditated murder, the state must prove the defendant intended that the killing of Daniel Markell occur. Then you heard the instruction of a principal when active participant is hired by the defendant. If the defendant paid or promise to pay another person or persons to commit a crime. To commit a crime means she paid or promised to pay them before they killed him. There is no evidence of that at all. She never paid any of her money. All she did was write the checks that her son told her to write from his business account. Says you have to show that she made or promised the payment in exchange for the commission or promise to commit the crime or to help commit the crime. Nothing. There's nothing at all linking her to Catherine McBanawa, Sigfredo Garcia, or Luis Rivera. Her link to Charlie Adelson is it's her son. They like to show those little arrows going back and forth like it's a train, I think they said. This isn't a train. This is somebody's life. Danny Markel's life. And now Donna Adelson's life. This isn't cute. This isn't powdered sugar. They have charged my client with first-degree murder, conspiracy to commit first-degree murder, solicitation of the people to kill, and their example is she's got powdered sugar all over her. No, she doesn't. They want you to believe it. That's their theory, but a theory doesn't prove a crime. They have to present evidence, and they haven't done that. Let's talk about Vietnam and the evidence that the state has introduced. Their exhibits 129 and 130 are the visas for Donna Adelson and Harvey Adelson. That one's Harvey's. Would you put that on? Now, there's something very important about these. It says their name and what they're going to do. You see that line? It's in, I guess that's Vietnamese, but underneath it, it's in English. And it says good for single/multiple entries. That it is a visa for tourism, not residence. It's a visa for tourism. They can come and go as they please. And that it is good until, where's that date? Here it is. It's good until, they put the dates backwards. So this is February the 5th of 1950. And the state says, oh, well, she was going to be gone past the date of the bar mitzvah. This visa allows them to come home, and if they want to go back, go back. Now, here's something really important. The state said that we're trying to tell you she was going on vacation. That's not true. Her prior attorney testified that before there was a conviction, she was very upset and said she wanted to kill herself if her son was convicted. And her husband was concerned about her doing that. So he wanted to get her away, to clear her head so that she wouldn't take such a drastic step. That's not a vacation. She's beyond herself. And then he gets convicted. And it's worse. And here's the thing. The state has been saying, since this woman was arrested, that she was going to flee this country to avoid prosecution. Flee. She's going away. She is not coming back. She's going somewhere where we could never get her and bring her back. They took almost nothing with them. They took a few credit cards, some cash, 2 pieces of luggage, and 1 carry-on. This is Defense Exhibit 147. When the search warrant was executed, after Mrs. Adelson was taken into custody, here's the luggage in plain view with the tags on it to go to one stop and then to Vietnam. And that's terrible. I'm sorry, I'm not criticizing. I think you got to hold it. In any event, there's the luggage. It's there when the search warrant is executed. And the gentleman from Miami, what did he tell you about that when they executed the search warrant? They didn't even look in the luggage to see what they had. Not even look in the luggage. More important than that is they conducted, according to him, a thorough search. And this is State's Exhibit 160. And it's not real easy to see, and I might just have to pass it along to you because this is really blurry. You see that? You see that little light down there underneath the white shirt? See that? That's the size of Mrs. Adelson's safe, sitting there on that little shelf. They never even bothered to open it and look in it to see if there's any stapled cash. That little bitty safe on that shelf, is that where she allegedly got $138,000 in cash and washed it and stapled it after she got this phone call and took it up to Charlie? Never happened. Couldn't happen. Wasn't going to happen. And the investigator was so concerned about it, he never even touched it. But here's what the state presented. And just like so much other evidence that they presented in their case, this is a state witness. And on cross-examination, when asked, Sergeant Chris Corbett testified there was no proof that they were actually going to flee. When confronted with a 90-day visa, his testimony was, well, they were going to be gone a long time. That's not fleeing. That's not avoiding prosecution. She got arrested almost 2 years ago under that claim. And it took them almost 2 years to come in here and have a jury seated on these serious charges. And they finally admit there was no evidence that she was going to flee. Danny Markell was killed on July the 18th of 2014, and Mrs. Adelson, according to Agent Sanford, was a person of interest, but she was not arrested in 2014. They immediately started, according to him, gathering bank account information, emails, phone records of Donna Adelson. 2015, she was not arrested. In 2016, they conducted the bump operation against Donna Adelson, and we've just gone through that entire bump operation. And still, even though others were arrested, Donna Adelson was not arrested. She was not arrested in 2017. She was not arrested in 2018. She was not arrested in 2019 or 20 or 21 or 22. Not arrested. And what did Agent Sanford tell you? That they had listened in on this call or heard the recorded call where Mrs. Adelson thinks she's gotten cut off from her son, and she's talking about going away, getting airline tickets, and she wants to kill herself. She talks about it on there. She wants her and Harvey to do it together. And he wants to get her out of town and away from the media and clear her head. And Agent Sanford said, here's how invested he is. They think they might get a warrant for her on the day that she's arrested. They're not sure if they're going to try or not, but maybe they're going to. So he's up here in Tallahassee, and what does he do? He hops in his car and he starts driving towards Miami, not even knowing whether they're going to try to get a warrant. When Mrs. Adelson got her visa, there was not a warrant. She was doing nothing wrong. When she booked the ticket, or Rick Sugarin helped book the ticket, there was no warrant. She was not doing anything wrong. She got advice of her legal counsel that there was no warrant. There was no promise with Mrs. Kappelman, but her lawyer told her of the possibility if they got a warrant, she could self-surrender and turn herself in. She packed her bags, no warrant. She gets in her car to drive to the airport, no warrant. She gets to the airport, and sometime therein, they actually get a warrant, and she knows nothing about it. They go to where she is seated with her husband, waiting for the flight to board, sitting down amongst the crowd, and they watch her and wait, even though they've got a warrant. They don't arrest her. And he gives some, oh, well, you know, there was a crowd of people. There's no more crowd than when you enter the jetway and everybody's trying to get on the airplane. They waited until she presented her ticket and walked through the little door so they could say that she was actually fleeing. It was a setup. They knew exactly what was going on. They set her up so they could claim, oh, we captured the matriarch murderer. She was fleeing the country to flee prosecution, never to return. It was a great story. Got a lot of headlines. Spun with their theory. But we're in trial almost 2 years later, and they know she wasn't fleeing this country. Yeah, I'm gonna sum it up here. And this is from the state's evidence. TPD, FDLE, the FBI, and one agency in Miami-Dade are all involved. They have people listening to phone calls around the clock, 24 hours a day during this 2-month bump period. In their investigation, in their words, they have collected hundreds of thousands of emails, over 2,000 phone calls during that 2-month period, recorded text messages, bank records. They got experts analyzing all of this stuff. They got cell tower records, and I don't even understand all that stuff, but it supposedly can place you in places. They've been working on this case, according to Agent Sanford, right up until the time he was sitting on the stand, still investigating Donna Adelson. If you were going to have proof that Donna Adelson committed a crime, you should have had it beyond a reasonable doubt before you put handcuffs on her in the Miami International Airport. They still didn't even know that day if they were going to arrest her. In all the evidence they have collected, she can't help herself but run her mouth. Not a single email, no phone calls that are recorded, no written documents, no emails, not one single thing that said anything about wanting Danny Markell killed. The most aggressive thing they have are her foul words and wanting to aggravate him. This is not, could she possibly have done it? Could she probably have done it? Might she have done it? You have been sitting here hearing testimony for almost 2 weeks, and there's not a single piece of evidence that connects my client to that murder. Charlie Adelson? Yep. Potentially Wendy Adelson? She's the one who said she hated him. She's the one fighting with him in court. Donna Adelson? Nothing. Not a single piece of evidence. You have to find her not guilty because they have failed to do their job on all 3 counts. They cannot prove she had him killed. At the time that he was killed, she had paid anybody or asked anybody to do it. Please take this case seriously. Please go back and review the evidence. Please discuss what's been presented. Don't get talked into something that you don't agree with. The verdict has to be unanimous. If you don't reach an agreement, if you can't be unanimous, there's another procedure we go through. But please don't buy into what the state is about to do, telling me how wrong I am or telling you how wrong I am about everything and how they have this mountain of evidence, because they admitted it. Agent Sanford admitted it. There is no direct evidence linking Donna to anything. And all this circumstantial evidence isn't really circumstantial evidence. It's argument about what it could mean, what it possibly mean. Could it have been? That's not beyond a reasonable doubt. Thank you.
Ms. Fulford, State, you may give your rebuttal.
Well, y'all tired of hearing lawyers talk yet? Down for another hour or two? Kidding. I think I've got 7 minutes. He hasn't started the timer yet. I haven't. Okay. It does not matter what Miss Fulford thinks, if she's right, if she's wrong, if I'm right, if I'm wrong. What the lawyers say is not evidence. You have the evidence before you. They say it means one thing. I say it means something else. Only you guys decide, right? I think outside your house means outside your house, but apparently outside your house means something else. I think a very contentious divorce means a very contentious divorce. They think it means an amicable divorce. You guys decide, right? Look at the evidence and you guys decide. Is everything not what it seems and actually something else? You guys decide. A TV repair appointment is not an alibi because she could have changed it to earlier, but she didn't change it to earlier. That's where she was when he was getting killed. That's an alibi. This TV, that doesn't mean, that's not code, that's a hint. A hint for what? It's code. What does it involve? The two of us. Oh, well, that actually means it doesn't involve the two of us because we're being extorted, we're victims, it doesn't involve us. So what does it involve? The two of us actually means it does not involve the two of us. That's what we've heard. A one-way non-extradition ticket to Vietnam? It's not fleeing. It's a setup. How did I set her up? I didn't make her do that. I didn't get her a fast-track visa. I didn't get her a one-way ticket. She did that. She made those choices. Wendy didn't bother to tell her mom she was ready to give up on the relocation. Yes, she did. Look in the emails. She was giving up and Donna wasn't having it. That's when she gets the totally unhinged email from her mother suggesting, you're not going to give up. You want to move on with a sense of peace? Hell no, we're going to fight this guy. We're going to dress your kids up as Nazis. That's what happened when when Wendy suggested giving up. Never, never, never give up, right? This murder charge is not based on the fact that she said some bad words. I mean, I'd be facing murder just in this courtroom. Obviously, people. That is not what this case is about. You've got to look at all the evidence. I mean, it is death by 1,000 cuts. It is powdered sugar. You've got to look at the whole thing and make a decision. And I'm sorry that there's not a smoking gun, but she was too smart for that. She thought about it. She planned it. She made sure we could never get her, right? She took precautions, but she did make mistakes. And that's what all those exhibits are. Mistakes. My spin and the spin I'm putting on all the evidence, that's not, it doesn't matter what my spin is. It's your spin. You look at the evidence, you decide. I tell you what I think it shows. They tell you what they think it shows. Here's the other side. And what do they think it shows? They don't have to prove anything. I have to prove the case. Yes. But what are they saying? Wendy, oh no. Charlie, definitely. Wendy, maybe. Not Donna. But also, not Charlie. We were getting extorted. Not Charlie. I mean, you can't have it both ways, right? It's like hard to get your head around it, but we can't be getting extorted by the killers who killed Dan Markell on their own. And also, Charlie's pretty guilty and Wendy looks a little guilty too. It's got it like, there's no lane that's been picked. And they don't have to prove anything, but they're throwing all that out, right? And it's like, you were getting extorted, or Charlie and Wendy did it behind your back and they don't tell mom what they're doing. can't charge Donna because Charlie already went down for this. No, that's not true. Everyone that's responsible for this murder should be held accountable for their role, not just Charlie, not just the two killers that came here and shot him. Everyone that played a part in it should be held accountable. They said some things in their closing that doesn't comport with my recollection of the evidence. For example, Corbett said that the defendant did not send the Evite. My recollection is the complete opposite. You guys took notes, you have remembrances, you guys rely on your own memory. I don't want to go through every single thing, but there were a few of those. The only complaint from a 3 and 4 year old was grandma says you're stupid. Oh, that's dumb. Well, no, I remember that the kid also said grandma hates you. Rob has an axe to grind. Mary Hull said that the Adelson Institute was Charlie's until 2022. Not my recollection, but hopefully you remember that it changed hands in 2015. No SunPass records. Do you need SunPass records to know that Donna Adelson was outside Charlie's house on the night of the murder? We didn't know that. Catherine Magbanoa told us when I got to Charlie's, he told me his parents had just come, right? And brought the money. But when we looked in the records, there's a text outside your house corroborating what she said. That's important. She was outside his house. Oh, well, she had the garage code. Why didn't she go in? I don't know if she went in. Maybe she did. She told him, I'm outside your house. He said 10 minutes. It's going to be there in 10 minutes. Maybe she did go in. I don't know. But she was there. That I do know. I don't know why she's denying that. Grandma motion. We disagree with what the words say. I mean, I don't know what to tell you. I say the words say, I don't want the kids around grandma because she's disparaging me. Somebody needs to be there to monitor. They say, no, that's not what it means. It means something else. Charlie's extortion story. She wrote the checks because she had to save her son's life. Well, right. So if that's the case, we're picking lane 2 here, down below. And that's where all that evidence comes up about that pushes back on that. Like that couldn't happen. They're not going to be spitballing the drug dealer defense years after they've been extorted. Like that didn't happen. That was a lie, right? That Charlie came up with in his testimony, and that she then kind of got stuck with after saying all the truth is out, truth is out, truth is out. Plus she's got to come up with something for writing those checks. She paid for the murder.
Please continue.
Sanford said he never made a mistake. Not my recollection. What's the pushback on extortion? Her behavior on the wire. She doesn't say, oh my gosh, it's happening again. She doesn't say anything about the prior extortion. If the prior extortion had occurred, she would immediately tell him it's happening again, or some reference to the fact that this is something that's been ongoing. She doesn't do that. Instead, she talks in code. It's a TV. What the heck? Why are you talking in code? Her Googling extortion versus blackmail 7 days before Charlie's trial. That wouldn't happen if the extortion was real. She wasn't extorted. Charlie didn't tell her there was an extortion because there never was an extortion. She was paying for a murder. She knew it was going to be a murder. She's the one that wanted it done. Her discussion of Charlie's lawyers meeting with Garcia's lawyers. What? If she was being extorted by Garcia and Charlie was being extorted and his life being threatened by Garcia, their lawyers aren't going to be meeting up. Look at those text messages. She said, bring cash. They say, oh, that's not code. She said, bring cash. She literally said, bring cash for dinner on that call. It's not a hint. It's a code word. They say the bump failed. I say the bump succeeded. She said it involved the two of us. That was before we got made, before that Matt Surrey operation where they literally see the camera in the bag and know the camera's in the bag. Yeah, she called and put on a great show when she called the undercover. But what did she say in the first call, the second call, and the third call before we got made, before she knew it was law enforcement? She said it involves the two of us, both of us. To these, okay, I want to hit one more thing. Don't call time on me. 2 years after the murder, we've got two emails, 64T and 64I. The defense told you in opening that this defendant cares about others more than she cares about herself. The problem is that she decides what other people need, what's necessary for other people in their lives, and she is willing to justify whatever ends she thinks are needed, right? Any means to get to those ends are justified in her mind. The problem is she doesn't care about the collateral damage to get to her ends. The evidence has shown that this defendant, I think, did believe that Wendy and those boys were better off in South Florida. She thought that's what they needed. They would be better off with her. And she was angry that that couldn't happen. Dan Markell is the thing standing in the way. What was the cost of that to not only Dan Markell, but to those little boys? Those little boys lost their father. Look what she says in 64T. Children are 2 and 3. Children do not even have a memory of life before age 5 or 6. Look what she says in 64II when Wendy is concerned. This is 2 years after the murder. Her child is having trouble at school, crying because he misses his father. And this woman, this nice grandmother, innocent woman, says, quote, I still do not believe that Ben is sad about his father. Quote, quotations on the sad. 64II. I still do not believe that Ben is sad about his father. I spend a minimum of 25 hours a week with him, and oftentimes more than that, including weekend times and sleepover days, and have never experienced a time when he was sad. I think it's just another phase of the many, many phases that kids go through. The problem is they have a highly intelligent and sensitive mom. She doesn't believe that this kid is sad because she can't take accountability for her own actions and the catastrophic consequences that this had on everyone's life in her family. Not just her son, not just her daughter, not just Rob, not just Dan Markell, but those boys who lost their father. It wasn't better for them to be in South Florida. It was better for them to have their father. You must not base your verdict on the feelings of sympathy, prejudice, bias. Your verdict must be based on the evidence and the law. Yes, she's a grandmother. Most murderers don't look like that. But the evidence has revealed what she is. Please don't let her appearance influence your verdict in any way. It involves the two of us. What about the script? They didn't even talk about the script. She wrote a script for a witness that was perjured testimony based on a lie, an extortion lie that's been proven in court to you to be false. This defendant tried to erase Dan Markell, thinking there would be no harm to those little boys. They don't have a memory of their father. They feel the absence of their father. This defendant decided they didn't need their dad. She doesn't get to decide that. She wanted it done. She brought the money. She stroked the check. She didn't have to do that. Charlie was a signatory, had signing power on that account. He could have written the checks. She wrote the checks. Why? Because she was neck deep in this thing. She wrote the checks. She said it involved the two of us. She wrote that script. May you have the strength and the common sense to see this evidence for what it is. It's only one thing. There's only one truth. It can't all be right. It's only one truth. Render a verdict that does justice. Find her guilty. Thank you.
In just a few moments, you'll be taken to the jury room by the bailiff. The first thing you should do is to choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The photographic, disc, jump drives, reports, and document exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see any other exhibits, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Before the deliberations begin still afternoon, we are going to discharge at this point the alternate jurors. If the clerk could please read out the names of the alternates. Please let the bailiffs know. I will have my assistant contact you with that information. We thank you for your service. You are excused at this time. Members of the jury, you may follow Ms. Tolbert and Ms. Vance. Your instructions and your notepads with you at this time. One moment before you go back in. The transcripts of the recorded call, these are to remain out here. Please leave those in your seats. Only the jury instructions and your notes. I'll send you a bill. Deputy Bunk, if you can check on the radio to see if there's another jury room possibly that they can be taken to temporarily while the headphones and the audio equipment is moved.
Okay, Judge, we learned that the headphones can just be unplugged and stuff already set up back there for them to plug them in, so we don't have to do anything with that.
Well, that makes that perfect then. Everyone can be seated. If the parties can review the items that will go back into the jury room with the jurors. The instructions that were read aloud with a copy of the verdict form. You can inspect that as well before it goes back. I will hand that to the clerk at this point. Instruction 4.2, instruction upon discharge, that will just remain out here as the case is not yet concluded. Also, please leave your phone numbers with the clerk, so that way if there is a question or a verdict, everyone can quickly assemble. Unless there are any other matters to address for the court, we will be in recess at this point. I'm aware. There's instructions.
And the verdict form is in here.
Verdict form is in there. Check for pages 8 and 9. For everyone else, you may step outside the courtroom or you may remain at this point. We will be waiting for the jurors. whatever the verdict will be in this case, I do not want there to be any gesturing or anyone making any movements that you either agree or disagree with the verdict. We are going to respect what the jury's decision is, and we are not going to subject them to any displays of emotion, whether it be from the gallery or the parties. If anyone believes they are not capable of following this instruction, I'd ask you to step outside at this time. Mrs. Adelson also as well, once the verdict is read, again, I'm going to advise you, do not have any displays of emotion as best you can. You are to control yourself. Do you understand? Please bring in the jurors. Please remain seated when the jurors come in this particular time. If the jury foreperson could please rise. Has the jury reached a unanimous verdict? No. If you please can hand the verdict form to the bailiff. Having reviewed the verdict form, it is in its proper order. At this time, I will publish the verdict. We, the jury, find as follows as to count one of the indictment, first-degree murder. The defendant is guilty of first-degree murder. Mrs. Adelson, control yourself. Count two. We, the jury, find as follows as to count two of the indictment, conspiracy to commit first-degree murder. The defendant is guilty of conspiracy to commit first-degree murder. Count three. We, the jury, find as follows as to count three of the indictment, solicitation to commit first-degree murder. The defendant is guilty of solicitation to commit first-degree murder. And it is signed and dated by the foreperson. One moment. Members of the jury, the bailiff will escort you to the jury room. Mrs. Adelson, while this was not the outcome I'm sure that you desired, there will not be any further outbursts in front of the jury. If you cannot control yourself, I am going to have to determine if you'll be removed from the remainder of this process. Do you understand what I'm saying to you? Do you need a moment to collect yourself? Before the jurors are brought back in, we will take a brief 2-minute break. Please give her tissues if she needs them. When the jurors are brought back into the room, does the defense wish to have the jurors polled before they are discharged?
Yes, Your Honor.
Very well. Please bring back in the jurors so we can conclude with their portion of the trial. Members of the jury, before I discharge you for this evening, I am briefly going to poll you concerning whether your verdict is unanimous at the request of one of the parties. When you hear your last name, please appropriately respond. Give to you before you are discharged. Please listen carefully. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges that are enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. With that being said, I want to extend my thanks on behalf of the entire Second Circuit for your service in this matter. You are discharged. Have a good evening. As to the jury's verdict, with the jury having found the defendant guilty of the 3 charges of the indictment, is the defense asking for a pre-sentence report on counts 2 and 3. As to count 1, the penalty is statutory, and essentially there is no modification for it.
Yes, Your Honor.
Well, pre-sentence investigation and report is ordered by the court as to counts 2 and 3. As to count 1, is there any reason why we cannot proceed to sentencing on this matter?
Your Honor, we would request an opportunity to ensure that our client is okay before we proceed to sentencing. It's my understanding that Charlie Adelson wasn't sentenced right away. We're asking for the same purpose.
Very well. The court then will set a separate sentencing date.
May I inquire whether the family members that are present would like to give victim impact now or at the future date?
Go ahead. It's fine. Right there in front of the lectern. If you please can identify yourself for the record.
Yes, my name is Ruth Mark.
Sorry?
Sorry?
I'm worried you're gonna trip.
Okay, I already did. My name is Ruth Markel.
You may make your impact statement, ma'am.
Thank you, Judge Everett. To the Honorable Judge Everett, my name is Ruth Markel. I am the mother of the late Dan Markel. I stand before you today to express the profound sadness and grief that Dan's family and I have endured since his tragic murder. We have lost a treasure. My son Dan's life was cut tragically short at 41 years old. For 11 years, we have been forced to a life filled with unimaginable pain and heartbreak. Dan's father, Phil, and his sister, Shelley, share in this unending sorrow. Dan was a devoted father, brother, and son. Dan's life was marked by his devotion to family, education, and community. He was a loving, caring, and inspiring person. His academic journey included studying politics and philosophy at Harvard University, earning a master's degree later in political theory from the Hebrew University of Jerusalem and the Emmanuel College in Cambridge, and later going back to Harvard to get a law degree. Dan was a prolific scholar and did start, co-founded the influential Prof's blog. His energy, drive, and sociability greatly enriched the FSU College of Law. Dan's life was filled with passion, music, dance, sports, travel, and people. But of all my son's accomplishments, however, I am most proud of the devoted father Danny was to his 2 sons, Benjamin and Lincoln. Dan was present, loving, and supportive, always putting his children's well-being first. He regularly attended the boys' daycares, reading with them. His office was filled with their drawings, and his home, his living room, filled with their toys. Dan was the boys' hero, and they have been forced to grow up without a father. Dan's murder has shattered our family and caused deep permanent pain. This was a particularly senseless crime, And the murder was particularly insensible. It was not revenge. Dan was a law-abiding and respectful citizen, an active father, and a living son. His life was devoted to teaching and helping others. The pain and suffering of Dan's murder goes well beyond other families too. That is why I wrote the book, A Mother's Unveiling, The Unveiling, A Mother's Reflection on Murder, Grief, and Trial Life. In my unrelenting grief, I turned to advocacy, to feel purpose, and to help others with these tragic losses. I have found meaning and comfort to connect with others who want to serve justice. To all the community of journalists, TV programs, podcasters, Tallahassee communities, and the allies who have put their hearts in keeping Danny's story alive, we are full of thanks. To law enforcement and prosecutors, our gratitude is beyond for their dedicated, careful perseverance in seeking justice for Danny and our family. If Tallahassee is known for football, Tallahassee should be known for the prosecution and for law enforcement. They have done an outstanding job. These extraordinary efforts underscore the brutal truth of our family story. Danny's murder was orchestrated by his former mother-in-law, Donna Adelson, and other co-conspirators, and is a crime of cruelty. It is a murder of grief, a murder of selfishly prioritizing one's own desires over what is just or right. And at its core, this was a murder of convenience, so that one grandmother could live closer to her grandchildren. She killed their father and ripped the children from the other grandparents' lives. Donna Adelson's crimes against Dan began long before his murder. She belittled Dan in front of his children. She spread lies about him and contributed to a brutal separation between Dan and Wendy. She rented the house, and Dan came home and he found that Wendy and the boys were gone with most of their belongings. He called this devastation Pearl Harbor. Donna's eagerness for Wendy to divorce Dan and to relocate to South Florida led her to increasingly devise desperate schemes. Despite these efforts, the court ruled that Wendy could not move the boys away from their loving father. Failing to achieve her goal through legal means, Donna finally resorted to orchestrating Dan's murder. She plotted, planned, and paid for his murder. Donna's crimes led to further devastation. Her middle son, Charlie, was convicted and sentenced to a life in prison for his role in facilitating Danny's murder for hire. Can you imagine a mother involving a son to complete a murder? Donna's eldest son, Rob, an honest and decent man, is estranged from the family, and her younger child, Wendy, has decided once again to relocate to another state. Her actions and those of her co-conspirators have caused children to lose their parents. Catherine McBanowitz, Freda Garcia, and Charlie Adelson, also convicted, are all convicted for life and have lost access to their children. Prior to her arrest, Donna's recorded phone calls with Charlie reveal their lack of a moral compass or capacity for self-reflection. She blames external forces for her family's curse. They're outside of her, but she is the curse, and lashes out angrily at witnesses who looked and took the brave step to testify. Her modus operandi has always been to run from Tallahassee and then to try to flee to Vietnam. For our family, there is no such prospect for escape. Danny's absence, and that leaves a hole at the center of our lives, no matter where we go. Yet Dan's murder was not enough for Donna. His death was not enough. Danny had to be fully erased from his beloved sons. The boy's last name was ever changed, an extraordinary decision to excise the Markel name from Phil's only grandsons who shared his last name. And after the first arrests were made, Donna didn't allow the Markel family to have access for over 6 years. It was only when there was a phenomenal Tallahassee advocacy group that passed the Markel Act. The passage of this bill was immediately followed by our first invitation to see the boys after the arrest. The door only cracked open. Despite these efforts, we remain excluded from the boys' lives. We were not at their bar mitzvahs or graduations. We have extremely highly choreographed visits and communications. We only wait for the day that Benjamin and Lincoln will visit their father and his grave in his father's history and his grave in Toronto. We want nothing more. The facts of Danny's murder, are difficult to swallow. The experiences Phil, Shelley, and I have been forced to suffer are profound as homicide survivors and victims of the criminal system. The lives of Danny's 2 sons, our grandchildren, were forever turned upside down by this crime. Benjamin and Lincoln were only preschoolers when their father was murdered, and now they are forced to confront and try to understand the unthinkable crimes of murder and the Adelsons' involvement. Our lives will never return to normal. For those who love Danny and for those who Danny loved, there is no escape from the wicked effects of what Donna Adelson set in motion, carried out, and paid for, and for many years enjoyed the aftermath of. Donna Adelson has caused immense devastation and an untimely, undeserved murder through her actions. While no trial or verdict can ever heal the profound wounds caused by Dan's murder, justice must be served. I respectfully ask the court to impose the maximum sentence on Donna Adelson. Her lack of cooperation and remorse throughout the case demands justice, the justice that Dan's life and memory fully deserve. We are immensely grateful to the court for its careful and compassionate deliberation. Respectively, Ruth Markel.
Thank you, Ms. Markel. Are there any other victim impact statements this evening?
One more.
If you please could tell us your name for the record.
Good evening. My name is Phil Markel. I'm Danny's father. Judge Everett, I appreciate the opportunity to speak about the impact of Donna Adelson's actions on my families and the families of so many others. While this victim impact statement is addressed to you, Your Honor, it is also intended for the Adelson family, Harvey, Charlie, Wendy, and particularly Donna. I would like them to understand and reflect on the deep and irreparable damage they have caused. The pain that they have caused my family is obvious and permanent, but they have also caused lifelong harm to their own immediate family and so many other families and children around. Donna's selfishness, cruelty, and complete disrespect for human life, along with that of her co-conspirators, have left families forever broken. Louis Rivera, his children have no father. Catherine Magbanoa and Sigfredo Garcia, their children have no parents. Charlie Adelson, his son, Roman, has no father. Rob Adelson and his wife and their 2 children have lost their uncle and grandparents. Shelley and Ian, my daughter, their 3 children, my grandchildren, are left without an uncle and are separated from their cousins. Of course, their heinous and callous actions have left me, Ruth, and Shelley without our Danny, and Ben and Lincoln without their father. For anyone to commit such a cold-blooded, unprovoked act of murder is horrific. For Donna, someone who claims to care so much about Ben and Lincoln, her sunshines, her actions are beyond comprehension. She has harmed forever the people she claims to have loved. In the Jewish custom, we have an expression to always wish others to live to 120 years of age. For Donna, I wish her to live to 120, alone in her jail cell. I wish that every day of her remaining days, she thinks about the harm she has caused to so many, especially those two boys she claims to have loved so much. For these reasons, Your Honor, I ask the court sentence Donna Adelson to the maximum possible sentence. And my only short question to Donna, was it worth it? Respectfully, thank you.
Thank you, Mr. Markel. Are there any other matters that the court needs to address this evening, Ms. Koppelman? With the PSI being ordered, the court will pronounce the sentence as to counts 2 and 3 after it's been completed. The parties have had an opportunity to review the pre-sentence investigation report and make any objections if they believe they need to. As to the 3 counts the jury has found the defendant guilty of, I will adjudicate her guilty at this time, but the sentence will be pronounced as to the 3 counts at a later date. She is remanded for sentencing at this time. Lieutenant Henry, please notify the commander at the jail that the appropriate screening needs to take place to ensure that the defendant is in an area where she is not subject to any self-harm. For a case management date coming up, what would the parties request?
Ms. Dugan's October court date, Your Honor.
Leave that is 10/14. Is that correct, Ms. Dugan?
Yes, sir.
October 14th for case management at 2:30 p.m. That will be in the normal courtroom 3B. Patricia, if you can make sure that the notice goes to DOC so they are aware that the PSI needs to be completed as soon as possible. Thank you. We are in recess at this time. We will reconvene on October 14th. Have a good evening, everyone. In the morning or all day? Oh, I'll have some time tomorrow. Some things between the public defender and private. Between public defender, regional counsel. What's that? I was going to say, I think it might be closer to 3. we are not finished with the colloquy quite yet. I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on. Mrs. Adelson, the question remains. As it relates